Okay, folks. Thank you all very much. Let's go ahead. Yeah, let's go ahead and get started. Thank you, because we have a lot to cover today. And sooner we start, sooner we can finish. Yeah, pick up a packet if you don't have one yet. A couple of housekeeping things before we get into the materials for today. First of all, we have, after today, 2 more sessions. Next Friday, which will be a short session, will cover business entities. And as I say, that one's going to be short, to the point, and it's very valuable. Should last hour and a half to 2 hours max, okay? Then the following Wednesday, which is 17th, 18th, whatever that Wednesday is, that's the review session. Now, but before we get into that, we have someone who has stopped by, and Dean Garcia, take it away. Came for pizza, yeah.
How are you? How's the pizza taste? You have pizza today, I guarantee you'll pass the bar. Well, I know you all are in the last stretch of a very difficult journey. And it's a marathon, not a race. If you've been studying steady all along, I am positive you will all pass. Because it's how much work you put in. That's the name of the game. And your presence here shows that you're taking it seriously. And most importantly, you've got the best right here. You've got the best right here. You can believe the number of calls I get from people saying if they can use Dean Singer's services, and I said, no, she's ours. You can't hire her. She's going like, Garcia, you're chipping me out of money.
Yeah, really, yeah.
But look, I was in your chair once. I know how rough it is. I stayed in Gainesville and locked myself in a room because I didn't want to come to Miami because I'd have too many distractions. I've never studied so hard in my life, and when I came out, I thought I'd flunked it, and I passed it. Here's one piece of advice, and I don't know if Dean Singer is giving you that piece of advice. When you take the bar, forget about it. Don't listen to people. Some people are masochists. I would hear people after the bar in the bathroom saying, what'd you think of this question? Yeah. It's like, you can't do anything about it. Yeah. And if you're wrong, you're going to be worrying and thinking, gee, somebody, I answered this thing wrong. And whatever you've done, let me tell you a little true story. Whatever you've done to prepare yourself for exams during your law school career that's worth, do the same thing to the ball. I had a couple of classmates when I took a bar in Tampa who said, you're going to flunk. And I said, why? I said, we saw you running the day before. I said, if I don't know this stuff now, and the physical exercise helps my mental, then I might as well hang it up. You know, the cue cards aren't going to do me any good now. So whatever's worked for you in the past will work for you in the future. So best of luck to you. I know that you all are going to do well and represent us well and make us proud. And you've got the best shepherding you here. So give yourself a hand for putting yourself through this.
Now, thank you very much. Okay. All right, so that's number one. Now, number two, I was starting to talk about the review session. The review session is for you. It's the Wednesday before the exam, so the exam's getting close. And I completely understand if you are somebody who needs to go underground during that week. However, I think students have found the review session to actually be really valuable in the past. So 2 things about it. It's for you, so if you can feed me things in particular that you want to talk about, I'm happy to try to steer the conversation that way. It's scheduled from 1 to 6. I don't know when we get kicked out. It's in the atrium because it's a Wednesday and rooms are at a premium here at St. Thomas on a Wednesday. Even if everybody who's in this room showed up, there's still room in there for everybody. It's bigger than you might think. So what I'm going to ask you to do, two things. You know, if you want to come and there's something in particular you want to talk about, you let me know beforehand. That's number one. Florida or MBE. I mean, we're you know, and we'll cover as much as we can within the time allotted. I had one group a few years ago who kept me here till about 9 o'clock, and nobody kicked us out. And if people want to stay that late, I will. So again, it's your session, so you let me know what you want to talk about. Now, we will have slightly more upscale food. Slightly. Well, is this St. Thomas? Okay. We do have a budget, but we're going to do sandwiches and stuff, so I will need some kind of head count so that we can prepare the food properly. Now, without any obligation at this point, just kind of a show of hands, how many people think you want to come for a session like that? And don't worry about it if you don't, you know? Okay, pretty much everybody. I'm sorry? Yes. Yes. Okay, yes, absolutely. So we'll remind you on that, and Sarah will let you know a little bit more on the food for that. Next week again, though, is business entities. Should be a short session. Now, finally, earplugs. We always supply you with earplugs. Feel free to, I'll walk around with them. If you want them, great. If you don't, you don't have to take earplugs. We will also have earplugs for you. Career Services will have earplugs for you in Tampa if you need them. Now, please think about using earplugs unless they drive you absolutely crazy, because the room is hugely distracting. Talk to anybody who's been there. It's an enormous room. People are always walking back and forth, and so, oops, sorry, somebody's always bothering you. The earplugs help you tune out. What you can't, you have to use something like this or like the earplugs I wear to concerts. You can't have any wires. So if you have your own earplugs and they have wires on them, take the wires off.
They don't allow like those noise canceling.
No, they do not. The reason that they don't is because, for the obvious reasons, no one has yet figured out how to connect these little foam earplugs. Somebody will, and when they do, then you'll have to change. But right now, they're safe. Noise canceling, not going to happen, unfortunately. Okay. You're welcome. All right.
I think everybody signed.
Everybody signed? Okay. Tracy, did I get you? No. Okay, good. Okay, before we jump in, any questions, any comments? Come on down, grab a packet. Except for Suzette, who just sent me essays, I think you're welcome. I'm pretty sure I'm up to date. If for any reason you think you've sent me something that I haven't sent back to you, then let me know. Because sometimes stuff kind of falls through the cracks or doesn't actually get to me. Yes, ma'am?
You said that you wanted the essay, the response, like the sample response?
No, the question.
The question and the sample response, or without the sample?
You can send the sample response, you don't have to. The key, the most important thing, though, is I know what question you're writing about. Okay? And you can continue to send them anytime you like. I would recommend that if you're going to send essays, so send them sooner rather than later for two reasons. One, I have to get them read, and you have to do them, yes. And you want to have enough time to respond. If I give you comments, don't send me an essay the night before the exam, because they're not going to help you out, right? Yes, ma'am.
If we send you like just the year, like family law, whatever.
That works too. Yes, family law, February 1997 or whatever, that works. That works. I just have to be able to find the question. Yes, sir.
Quick question. Does the school send out the final?
Oh, the question is, has the school? I know. If it hasn't been sent, it will be sent momentarily. And we keep asking the bar to leave you guys alone on that particular point, and they don't listen to us. What has to happen is the registrar's office has to do all of the final grade calculations, which can't be done until all the final grades have been submitted, and sometimes there are grade changes that happen even after graduation. I was assured by Dean Hernandez that they were in the process of getting those letters out. And we're aware, as I say, we keep saying to the bar, don't bug the students. The students can't do anything about it. And they kind of ignore, unfortunately, our pleas, and they keep sending you those letters. I apologize for that. I have no control over it on either end, but I promise you, each and every one of you who is sitting in this room, to the best of my knowledge, that letter is going to be going out, because we don't have anybody in here who didn't graduate. So
So
it's,
should we just write back and say, you know, we spoke to our school and they said? that
you
they
can,
said
you can ignore it.
don't even make
Yeah,
me get mad.
it's a huge pain. And,
They send you like a nasty reminder email.
Yes, by the way,
yeah.
we're missing.
Yeah, and you know, it's there. Enough said on that particular point. Okay, other questions though. All right, so we're going to do the Florida evidence first. Yes, sir.
One question
Yes.
about essay writing. And
Yes.
I don't know if this goes for everybody, but for me, it's at this stage, I should just be test-taking type style essay
Yeah.
writing, right? Like
Yep.
no, hey, let me look up that word or whatever, just go through it, send it to you, and then.
Yeah, right. Now,
From there.
I will tell you, as you write your essays, the most helpful thing for you is to write about something that you know about, right? And at this point, you should have studied pretty much everything. I mean, we have just a few weeks before the exam. It never helps to try to write an essay about something that you know nothing about. Really, then you're wasting your time. But if you've studied the subject, and if you haven't, let me emphasize, if you have not gotten to certain Florida subjects yet, get there really fast. Don't leave Florida for the last week of study. It won't get done, or if it gets done, it's the only thing you're going to remember for the exam. So get Florida out of the way really fast, and then spend the last couple of weeks reviewing everything so that everything's fresh in your mind. And assuming, again, that you've read the subject and you've looked at the Florida distinctions, then yeah, sit down, bang it out in an hour, and send it, so that you get the sense of, because I'll tell you, it's good, your substance good, it's wrong, and some things like Chris sent a Homestead question, which I think you guys could easily get. And there's some conceptualization that we're going to talk about, because the question that we're going to do on purpose, you'll recall that Judge Shepard said he was going to leave a certain part of Homestead to me. We're going to finish it up, and I'm going to show you the things that you want to focus on, how you conceptualize Homestead, because it's actually a very easy essay to write if you follow the format. So other questions? Again, we're going to start with Florida evidence, kind of get that one out of the way fairly quickly, focusing on the distinctions. And then we're going to do that Homestead, and we'll finish it up with family law at the end. So without further ado, pull out the Florida evidence questions packet. And it's very short. We will do all of these questions because it's very short, and it covers many, although maybe not all of the distinctions. I'll point out some other distinctions as we go along, but just go right ahead and jump into question number 1, and let me get this started. Hopefully this thing will work for us today. Anybody else on this question? Florida evidence questions, by the way, are going to be short. Short and to the point, and they are going to focus on the places where Florida law is different from MBE. Oh, sorry, I did the wrong thing. Oh, sorry. That's what I want. Pretty good, but not perfect. B is the right answer. All right? So, the question involves a learned treatise. And you know, under the federal rules, you can use a learned treatise to impeach. And for substance, there's a hearsay exception for a learned treatise under the federal rules. In Florida, there's no hearsay exception. So it may be used in cross-examination of an expert witness, but may not be used as substantive proof. Remember, of course, the witness has to be on the stand, and the portion is read into evidence. The document itself is not actually introduced.
Can't the cross bring it in? The defense counsel on cross?
Yeah, they can, but you don't introduce the book itself, you read it in.
Oh, it's never
Yeah,
admitted in as
right.
as an exhibit.
Right, correct. It's not an exhibit. Okay, number 2. Okay, anybody else? I think we're there. All right, see how we did on number 2. Oh, we're kind of spread out. Probably because some of us are confusing Florida and MBE. C is the right answer. Let's consider why. The call to the question says, if Ward is testifying as a lay person. Now, remember that Florida is very suspicious of opinion testimony. So some of you remember that. And so you think, oh, you can never use opinion in Florida. Well, not exactly. You can't impeach with opinion testimony. You have to use reputation, right? But if you have a lay witness can actually testify in opinion form if there's no other way that the lay testimony can be given. So think about it as a trial attorney. You figure out a way to present the question in which an opinion is absolutely required. So C is the right answer. This language comes right out of the rule. You can use lay opinion if there's no other way that the testimony can be elicited. And I don't have a question, but just to throw it out there, everybody should know the answer. If we're talking about an expert testimony, how's it judged in Florida now? Which standard do we use? Daubert. We switched from Frye to Daubert. So if there's anybody who's in doubt on that particular point, Daubert is now the rule in Florida. Questions? Number 3. Okay, anybody else? Let's see what we have on number 3. Very good. D is the right answer. We had a few people who didn't get it right, so let's make sure we all know why D is the right answer. Here, again, a difference in Florida. Under the federal rules, you've got marital communications and you've got spousal immunity. Florida does not recognize spousal immunity, so remember that. We do, of course, recognize marital communications, and we recognize it in the form that is used for the federal rules, which means, of course, you have to have a communication that's made during the marriage in confidence. And who owns the privilege then? Both parties own the privilege. And in this case, Clyde can be compelled to testify as to matters not told in confidence during the marriage. It's not protected, right? Okay, questions about, you will get a question. If you have evidence questions, and you're very likely to have evidence questions, you'll get at least one question that's going to try to draw you into spousal immunity. So don't go there in Florida. Question, Chris?
I get why all those are bad and why D is D. The one twist to that is if in Florida, the marital communication and you have the testifying spouse, like criminal husband, testifying spouse, the wife wants to testify. Can the husband block the testimony? But only if it was made in the marital sanctity or
You got it.
whatever, and then,
Correct.
Okay, so you have to look for that nuance and say like, well, was he walking in the door or were they like having a heart-to-heart about it?
Yeah, exactly right. Yeah, or are they out to dinner and they're in a crowded
So
restaurant?
like and
Yeah.
also the clothes, right? That's not.
Yeah, correct. That's not, because that's not a communication.
Yeah, exactly.
Okay? Yes, sir.
Just bouncing off of that, during the bar, would that be the type of question we would get, or is it something more straightforward as?
No, you.
They're gonna trick you.
They're going to make it. Yeah, they might.
Well, I just
Yeah.
want to make sure, because you had said earlier that
Yeah.
they're pretty straightforward.
They are when I say they're straightforward, in the sense that they're going to hit the distinctions, and you're going to know the rule or you're not going to know the rule. Now, it doesn't mean that you still have to talk about whether the communication is confidential, right? But and they aren't going to, they aren't going to split hairs. How many people were in the diner? How close? Not that, but you still might have to deal with confidentiality issues for sure. Remember also. Well, actually, let's do the next question, and then I'll make the comment. So, number 4. Anybody else on this one? This one's a little bit longer. All right, let's see how we did. Good but not great, and it highlights something that I actually wanted to point out in this question, the difference between C and D, which is an issue that you're going to get on both MBE and on Florida. So it's a two-tiered question. You have to decide what her statement is first, and then you have to decide if it's admissible. So we go back to her statement, and of course Samantha is the defendant, right? And she says, you know, I got hurt because I fell asleep while I was driving. I'm sorry, she's the plaintiff. But anyway, she says, you know, I got hurt because I fell asleep while I was driving. She is a fill in the blank in respect. She's a party opponent. And if she's a party opponent, it's an admission, not a declaration against interest, right? Don't make that mistake. That's a rule, same Florida and MBE, but that's the first step here. Identify what it is. And then ask yourself, of course, what's it being offered for? Here's a rare case where it would be offered for what? Truth of the matter. You know, when you're doing evidence questions, always think of everything but the truth of the matter. Here, it is being offered for the truth of the matter. And if it's being offered for the truth of the matter, the question becomes, since she made the statement to her physician, was it privileged? What do we know about patient-physician privilege in Florida? Doesn't exist. Now, mind you, there are privacy issues, but all you need in Florida is that subpoena, and it all comes out. Yes, sir.
Is that a blanket distinction between statement against interest and admission?
Oh, yeah.
So,
yes, absolutely. Statement against interest is somebody who's not a party. Absolutely. Statement against interest or declaration against interest means the same thing. It's someone who's not a party, and admission is a party opponent. Big distinction, and I promise you, it's a distinction that will be tested probably on both parts of the exam if you get evidence questions.
I never do that.
Yeah. Yeah. Little things like that can make a huge difference in your score.
It had something to do with civil or criminal. I was writing the wrong thing.
Yeah. Yes, sir.
But psychologists.
Yes. Very good.
Okay.
Very good. There is in Florida a huge list of privileges, and psychologist client is one of them. Psychotherapist client is what it's called. You've got penitent clergy. You've got the accountant. Yes, thank you. That's what I was looking for. Accountant client. You got everything under the sun in the Florida rules except for patient-physician. And of course, even under the federal rules, patient-physician privilege is extremely weak, right? Because most of the time, the patient goes to the physician and then brings a lawsuit, right? Which now means you've done what? You've waived the privilege because you put your condition in issue. So, but do remember, there is no patient-physician privilege in the Florida rules, and all you need is that subpoena, which is, and again, I took that statement right out of the relevant rule. And of course, again, distinguishing between a declaration or a statement against interest and an admission. Important distinctions. Any other questions on this question? All right, number 5. Okay, I think we're all in. a distinction between Florida and federal again. The question is about a bad act, right? Writing a check is a bad act. Can you impeach in Florida with a bad act? Nope. You cannot impeach. Under federal rules you can, but not in Florida. Now, it's not to say you can't use a bad act for anything in Florida. I'll come back to that in a second. But you can't impeach with a bad act in Florida. You can, of course, impeach with a conviction in Florida, which we don't have in this question. A few distinctions, though, to pay attention to when it comes to Florida versus federal rules in respect to convictions. No staleness, no 10-year staleness rule in Florida. There's no time limit in Florida. And the balancing of the probative value versus the prejudicial value that's required if the witness is the defendant in a criminal trial. Federal rules require that. Florida does not. The balancing. Remember, yeah, the probative versus prejudicial value that you are that the court is required to do under the federal rules when the witness is the defendant in a criminal proceeding, not required under the Florida rules.
So it's just whether it's prejudicial or not?
Well, there's a separate rule in Florida. You can, and in particular, it goes to staleness. You can still attack staleness, and then you're going to balance prejudicial versus probative there. Now, back to bad acts, though. Can you ever use a bad act in Florida? Yes, you can. Where do you think?
Sexual assault cases.
Well, yes, but broader. Where else can you use bad acts? Don't forget about it. Under the federal rules, where else can you use bad acts? How about the mimic rule?
Oh, yeah.
Oh, yeah. Now, I'm not big on the mnemonics. I rarely use them, but mimic's one of those places where you use it, right? What's the first M? Motive. Identity. Mistake. Absence of mistake, right? Or mistake, yeah. And the second I? Intent. And C? Common scheme, all right? Okay? You can use bad acts there in Florida. However, it's limited because they have to be strikingly similar. Not just close, but the statute says strikingly similar. And that's the name of the game in evidence. You can't get the evidence in one way, you get it in another. Question?
Do you know whether someone's already gone through the trouble of creating a nice handy chart that indicates the differences between the federal rules and the Florida rules for all this stuff, so we don't actually have to?
So you don't have to do it.
I'd like
yeah.
to accelerate the learning process here and not have everyone spend their time making the chart.
Yeah. I've never seen one that does quite that. There in the Kaplan book, there is something that comes kind of close, because it goes by line. It's not exactly what you're talking about, but Barbary has one where it does? Okay. There you go. Okay. It's worth, and let me say this about that. What I did to kind of create my own chart when I was studying for the exam, I cribbed the Florida distinctions into the MBE book so I could see them side by side. And I realized sometimes people get confused. Is it this one? Is it that one? Color-coded or something, so that when you walk into the exam, red is MBE, green is Florida, I don't care. But seeing them like that and knowing which fork in the road to go down can make a big difference, because otherwise those rules are going to be swimming around, and I promise you what they're going to test, all these places where Florida is different. Okay, any other questions about bad acts or convictions? All right, number 6. All right, let's see how we did on 6. Very good. Okay, this time that sort of broad rule works, doesn't it? Because we're talking about impeachment, and if you were listening to what I just said, if you didn't know the rule before, if you were listening, which is always good, in Florida, you cannot impeach with opinion testimony. There's one place where it is an absolute. You can use reputation, but not opinion. Of course, under the federal rules, you can impeach with either opinion or reputation. And always be cautious when you see a question on the Florida portion, Florida evidence portion. Be very cautious if you see opinion testimony, because it's not going to be that, oh yes, absolutely. It's very limited. Questions on number 6? All right, then number 7. We're missing a couple of people. Maybe your clickers are, remember, they turn off by themselves. All right. And let me assure you, if you, yeah, I was just going to say, if you get evidence, I promise you, I can't promise you a lot of things, you have to know this distinction. Oh, is it A? Is it C? Is it C? Is it A?
It's an exception in Florida.
C. Now, Florida follows, there are a number of places actually in the Florida Evidence Code where we follow the old common law rules, and this is one of them. Under the old common law, an admission was admissible hearsay. Under the federal rules, of course, it's non-hearsay.
Good old Florida.
Yeah. And practically speaking, it doesn't really matter. But for exam purposes, it matters a lot. So make a big note. If you didn't know that it's admissible hearsay in Florida, make a big note. Remember also, of course, in Florida, we already talked about the fact that you don't have a hearsay exception for learned treatise. We don't have any of those catch-all exceptions to the hearsay rule as well. Just be aware of that. It's easy to, get distracted. Okay. Any other questions on okay, number 8. Yeah, I got bored. Are we all in? We're not actually all in, but we think we're all in. It's the last one. If your clicker's not working, don't worry about it. Okay, once more, it's the old common law rule. Now, under the federal rules of evidence, habit is, of course, admissible. But in Florida, if it's personal habit, then we have a special rule, again, the old common law, which is that it must be used as corroboration. Now if it's business habit, it comes in. There's no corroboration requirement for business habit, but there is for personal habit in Florida. Now, before we leave, there are two other places I want to point out. I don't have questions on them, and then if you have any questions, of course. The first has to do with judicial notice. Under the federal rules, of course, you have judicial notice of facts, notorious, manifest facts. We know the difference between notorious and manifest. Notorious, the ocean is that way, right? Everybody knows the ocean is to the east, right? I know. I got to stop and think, where's east? To the east, that's notorious. Manifest, you can look it up. You can go to the almanac and find out when sun rises or sets or the tide comes in, right? And those are the two kinds of things that are judicially or can be judicially noticed under the federal rules. We have a very elaborate judicial notice statute in Florida, and I'm not going to recite all of the things. But first of all, there are some differences even with fact. Because under the federal rules, of course, the judge may take judicial notice of facts, but if somebody properly requests and provides the proper basis, then the judge must take notice, and then it's a question of how it instructs the jury. Under the Florida rules, it's a may all the way across the board. The judge may take judicial notice of notorious or manifest facts. And then, remember again, under the federal rules, if the judge does take judicial notice, how do we instruct the jury? If it's a civil case, it's a must, and it's a may if it's criminal. In Florida, the judge gets to choose how the judge is going to instruct the jury. In addition, in Florida, there is a long list of laws that come under judicial notice. It's not called judicial notice under the federal rules when it comes to laws. And again, I'm not going to recite the whole list, but it's pretty self-explanatory, and you can guess it if you don't know it. Because of course, the judge has to take judicial notice of the U.S. Constitution, Florida Constitution, right? Laws of Congress, laws of the state of Florida. It may take judicial notice, Supreme Court decisions, anything that's above it, right? And the judge may take judicial notice of laws from another state. The judge may take judicial notice of opinions from another jurisdiction. But the must is anything that's above the court in level. So again, remember that Florida considers laws something that the court takes judicial notice of, and then the differences when it comes to fact between Florida and the federal rules. Now, one final point, again, easy to test, has to do with presumptions. Federal, and you may not have talked about presumptions very much at all, because nobody ever wants to talk about presumptions. But under the federal rules, there's one kind of presumption that's recognized. Anybody know what kind it is? Bursting bubble, right? Okay, which shifts the burden of production but not persuasion. Yes, sir?
I'm trying to wrap my head around like that analogy.
Yeah.
Explain what, like I'm
Yep.
picturing a bubble that.
Yes, I will in a second. And I'm going to use the illustrations that they use in the Florida, that accompany the Florida rules. Because Florida recognizes bursting bubble and burden of persuasion shifting. We recognize both, and we have statutory examples in Florida. For example, in the area of wills and trusts, if you have a presumption of undue influence that's created, it shifts both burden of production and persuasion. It's a statutory shifting. So what's the difference between the two? Let me start with the bursting bubble. The example that they give is what happens when you put a letter in the mail. Nobody puts letters in the mail these days, but the example still works. If you correctly address and correctly stamp or put proper postage on a letter and put it in the mailbox, there's a presumption of receipt, right? Yeah, yeah. And then, so what a presumption does is you start out with certain facts, and if you prove those facts, then it shifts the burden of at least production over to the other party to rebut the facts and come back and say no. So in this example, the basic facts that we build, you correctly address, you correctly stamp, you put it in the mailbox. Presumption of receipt on the other end. Now it's up to the other party to prove that he or she didn't receive it. And that's what happens is the burden of production shifts. Now what's the burden of production? That's producing enough evidence, whatever it is, to get to the jury. Not to convince the jury, just to get to the jury, to avoid summary judgment, for example. So it's enough to get to the jury. Burden of persuasion is what happens when you've got the jury. Who loses if the evidence in a civil proceeding is 50-50? The burden, whoever has the burden of persuasion loses, right? So it's who has to actually convince the jury. So with our presumption that's bursting bubble, again for the mail, you shift the burden of production. As soon as you show correctly addressed, correctly stamped, put in the mailbox, now the other party has to say, prove, not say, prove at least enough evidence to get to the jury, no, I didn't get it. But when we get to the jury, who is it in the end who's going to ultimately bear the burden of persuasion? The plaintiff. Because the burden of persuasion never leaves the plaintiff. The plaintiff can shift the burden of production, but not persuasion. That's bursting bubble. Now, persuasion shifting is a little different, and the example that they give in the rules is the presumption that arises when two parties participate in good faith in a marriage ceremony. Then you have a presumption of that's just not only burden of production, but also persuasion to the other party to prove that the marriage didn't happen. And it's a tough burden to meet. Think about, for example, that burden of persuasion shifting that occurs with undue influence. If you prove that somebody is a substantial beneficiary, somebody had fiduciary relationship and active procurement in producing a will, for example, those three things, you shift the burden of production and persuasion to the opponent, who's then, the proponent of the will. That person then has to disprove everything. And basically, once you shift the burden of persuasion, the case is done. Go ahead.
I think what I was trying to say is, like, conceptually I understand it. But I was thinking, oh, maybe if I just imagine some sort of a bubble bursting, you know, it'll kind of like refresh. So I'm picturing a bubble. I mean, like, to me, the analogy, I don't understand how it makes sense. Like, even like, what's that other one? Like the courier without luggage. What are the elements of the
Oh, yeah, yeah.
Like, why doesn't he have luggage? I don't. Is he even a courier? Like, who's luggage? Like,
Yeah.
It makes no sense whatsoever if I try to imagine.
Yeah. I know when I taught commercial paper, which I did years ago, nobody talked about courier with luggage. So that's I wouldn't have taught it that way just because nobody thought of it yet. But the bursting bubble, I can explain what it means. I don't know that it's going to make any more sense to you. But the idea is if you meet your initial burden, so you put it in the mail, right? Now the bubble is created. That's the presumption, right? And now the other party has to stick a pin in it by producing enough evidence to get to the jury. If that party does, then the presumption goes away and you're back to square one.
So rebutting the presumption is
bursting the bubble, and it puts you back at square one, which is different from burden persuasion, because once the persuasion shifts, the burden of persuasion shifts, you never go back. There's the difference, if that helps. Okay.
On the burden persuasion for the Florida stuff, does that have to be proven or resolved prior to getting to the jury also?
When you say resolved, I'm not sure.
Does there have to be the evidence presented prior to being able to get to the jury?
You have to have enough to raise the presumption.
Because if they don't pop it, or if they don't provide evidence limits of the
You're right, then
you can go for J mall or whatever.
yeah, right, correct, exactly right. And remember, what you're doing is you have to produce at least enough to get to the jury. If you don't even do that much, then you're out of luck before you ever get to the jury, whether it's bursting bubble or persuasion shifting. So again, remember, there is a distinction there. It's easy to test. You probably aren't going to have to work with how the presumption works. That's the good news. But knowing that Florida does have burden persuasion shifting, and by the way, little note, it's got to be statutory. So it can't be a case-made shifting of the burden of persuasion in Florida. It has to be statutory. And the one I know, because I teach in the area, is undue influence in the area of wills and trusts. That applies to both a will and a trust. So kind of look for those kinds of things. Other Florida evidence questions that you might have. All right. We're going to, as I mentioned at the top, we're going to do the Florida con law question now. We're obviously not going to review all of Florida as con law again. We'd be here for a very long time, and we don't need to. But as I also mentioned, Judge Shepard had kind of punted to me on that question, and interestingly, we had not talked before, he and I. I had already intended to do a Florida homestead question because I think you might see it. And so take a few moments, read the question, pick out the issues, and then let's see what we have.
Thanks.
Okay, let's go ahead. Obviously, on the exam, you would take more time than I'm giving you right now, but let's do some of that analysis outlining together. So we're going to start up at the top, and first sentence tells us a lot, right? Because first of all, it says 1968. Anybody know why we care about 1968?
Revised the Constitution in 69.
You got it. That's the revision of the Florida Constitution. We don't have to worry about any old rules from the Constitution. So Mr. Adams inherits a home. Why does that matter? If he inherits, well, it's not what? Not marital property. Thank you. Exactly right. He inherits it, so they're telling you right there it's not tenancy by the entirety. Now, homestead, of course, can be tenancy by the entirety, but you have a different set of rules at one point. But we know that we aren't going to have to worry about that issue. It's on 1 acre of land. Well, okay, big issue, right? Because when we establish the homestead, we know it extends to how much? Half acre inside a municipality, 160 acres of contiguous land outside. Yes, ma'am.
I have a quick question. Since it was non-marital property, if they were,
It's not that it's non-marital property. It's not tenancy by the entirety.
I mean,
Okay.
But if, let's say you purchased it before the marriage, and he doesn't deed it to his wife before the divorce, but if they get a mortgage, then it's considered tenancy by entirety, or just the mortgage is considered? I know that if it's something in the book, if you have a marriage, then it can create a tenancy by entirety if both husband and wife get into the mortgage.
Well, if you don't automatically convert the property to tenancy by the entirety, but they can both be liable on the mortgage if they both sign it. That's number one. Now, number two, though, in Florida, maybe it might be part of what you're thinking. If an individual owns property separately in Florida, then he or she can create a tenancy by the entirety with the spouse without using a straw. There's a statute that specifically says that you don't need a straw for tenancy by the entirety.
But if they have the child, minor child?
Oh, that's a whole different issue. You're not there yet. You're not there yet. Okay? All right, so of course, child shows up in the next sentence. But what's really important, and it was a comment that I'd made to Chris, First thing you're going to have to do is establish whether the homestead has been created. So it's those elements. We need a person, right?
Yeah, natural person.
We need a natural person, which I want to comment more on as we go along. You need a natural person who makes it his or her permanent residence, and of course, half acre inside, 160 outside, contiguous outside, we have no dollar limit in Florida. It's just the size. And then, of course, occasional issue, partly tested here. It can't be abandoned, of course. But you establish the homestead through those elements. You don't have to go to court to establish the homestead. If you satisfy all those elements, you have a homestead. That's establishment. Now, there are 4 distinct areas that are homestead type issues, and you need to deal with them separately. Actually, let me take this down for a second. I have a little chart. Maybe it's worth spending a little time on this. I pulled it up. Where'd it go? Here we go. Okay. So your requirements we just went through, so I'm going to fast forward past that. Okay, sorry. Okay, first, restrictions on devise, which is an issue in this question, right? Or could be an issue because that's where Chris was going. But that's one issue. We have a minor child. And of course, if there is a spouse or a minor child, then the owner cannot devise the homestead to anybody. Period. End of story. If you have a spouse and no minor child, then the homestead can be devised to guess who? The spouse. Of course, there's no spouse in this question because they're divorced. If you have no spouse or minor child, then the property can be devised to anybody. We don't care to whom. There's a separate issue, though, about the inurement of the homestead protection. That's the 4th issue. So first issue, if it's raised in the facts, which it is here, is can you devise the homestead? Now, and remember, if there's, and I'll go ahead and go over it here. If there is, no, you don't. You know what? Because I just, well, I'll send it to you. It's something I use in wills and trusts, and I thought about it last night. I said, oh, you know what? This could be useful. I will send it to you. So remember also, if there is no divisor, if there's a divisor and it's not an effective devise, then the property is going to go to the surviving spouse. Now, the surviving spouse gets to elect. Surviving spouse can take under the traditional scheme, which is a life estate and surviving spouse, followed by, do I have that up there? Yep. Oops, oh, that's the next slide. Followed by, followed by a remainder per stirpes in the lineal descendants and being at the time of the owner's death. Or the surviving spouse can now elect for the last few years to take as a tenant in common with the lineal descendants. Spouse takes half and lineal descendants take the other half. So remember, the spouse gets the election now if you don't have a valid devise. And there, we don't need that. But now, second issue, protection from the creditors of the owner during the owner's lifetime. It's a separate issue. Don't try to discuss them all at the same time. Deal with them separately. So first is whether it can be devised. Second, is it protected from creditors? And of course, the answer is yes, with 3 big exceptions, which we'll talk about in the context of this case. So I'm not going to go into them in detail now. 3 obvious exceptions. They love to test this part of it, by the way. So again, we'll go into more detail in a moment. Now, again, the third is protection from, actually, this is really the fourth one. The second one is the descent. So I apologize. Should have said that better. First is, can it be devised? Second, what happens if it isn't devised? Third, protection from creditors during the lifetime. And then fourth, the inurement of the protection. Who gets to take the benefit after the owner dies? And remember here, I see people make this error a lot actually in essays. We're talking about the protection that extends, that was the owner's protection. So it's protection from the owner's creditors. If somebody gets the property by devise or descent after the owner dies, there is no protection from the new owner's creditors unless that person establishes his or her own homestead. Now, the protection is going to extend to anybody who could take by intestate distribution. There's case law on that particular point. And so the surviving spouse obviously gets the protection. The lineal descendants can get the protection, and anybody in the first 3 parentellas, anybody who is a descendant of the grandparents. Even if that person would, if that person takes by devise and would not have taken by intestate distribution under the facts as they are. So for example, a case, in the case book I use, some of you may have seen it, a man devised his homestead to his grandchild and had a child living. And the question was the property in the hands of the grandchild protected from the decedent's creditors? Now, you have the son, I think it was the son, in between. And so he would take by intestate distribution. And the question was, well, okay, she is an heir, but she wasn't the heir. And the court said because she could, not she would, but she could take by intestate distribution, the protection, owner's protection, inured to her benefit. So take each of those 4 things separately. The ability to devise, descent if there's no devise, protection from the owner's creditors during the owner's lifetime, and inurement of that benefit separately. Now, totally aside, we also have, whoops, I'm sorry, and we don't need to go into a lot of details here, the tax exemption. That's a whole separate issue as well.
Is that called the statutory or common? What?
Well, Save Our Homes is an important part of it. And remember that we have a cap on the tax rate. Can't go up more than 3% in a year, and portability as well, which was 4 or 5 years ago added to the statute. You can take your cap with you with certain limits. Okay, now let's take all of this and put it into the question. What did I do with my fact pattern? Okay, so now we've got Mr. Adams marries Mrs. Adams. So he gets married, and they live in the Miami home. Why does it tell you that they live in the Miami home? Okay, it's their residence, at least at the time, and it'll become an issue as we go along. They have 2 kids, Sam, born in 1971, and Dot, born in 1983. As we get along in time, Sam becomes an adult, right? Which matters, and Dot's still a minor. And we see Sam gets a job in Wisconsin, moves away. You know, he can still take the homestead, but he doesn't prevent the homestead from being devised to somebody else because he is no longer a minor. Now, Mr. and Mrs. Adams get divorced. And of course, and we're going to talk a little bit more about divorce when we get to family law, but of course when they get divorced, how do we treat her? As having predeceased him. And so her homestead rights go bye-bye. Under the divorce decree, Mr. Adams retained ownership of the Miami home, and he might, because you might want to, jumping ahead to the next topic, but you might want to preserve the marital home as a place for the children until they reach the age of majority. That's fairly common. So he retains ownership of the home, but Dot and Mrs. Adams live in the home. So what are they setting up here? 2 homesteads. And everybody thinks one homestead. Well, true, because we have to decide between Miami and Orlando, perhaps for Mr. Adams. But it is possible to have your own homestead where you live and the homestead for your spouse and children if you aren't living together. And that's something, obviously, they have tested. There was a particular case that was going up and down in the Florida court system when they wrote this question. It addressed exactly that issue, but more common than you might think. Okay, now in
Because you can have a homestead if you reside and have a less than a feasible absolute interest in it.
You can,
So
yes.
you have to walk down that line a bit after you got through all his stuff, and then abandonment of the homestead 1. At that point, you step in and say, because of blah, blah, blah,
Right.
you could establish this as her own.
Well, but it's his, still, he can claim the homestead because he's the owner. That's the key.
He had 2 permanent residents.
He doesn't. That's the point. It's the permanent residence of the family.
Okay.
Yeah. So if, now in this case, he didn't stay in Orlando very long. So he never really established, I think, a permanent residence up in Orlando, and then he moved back to an apartment in Miami, so he's not going to have homestead in the apartment. But if he had bought a home in Miami for himself, and his family still lived in the house that he owned in Miami again, so he's got 2 homes in Miami, both could still be homestead that he could claim. And of course, the wife could also, but she doesn't have ownership rights in this case, so she wouldn't be establishing homestead in it because she doesn't own it. So it sounds a little weird, but it's absolutely true. He establishes the homestead where he lives if he owns it, and then his family live.
So if he had owned that Miami place, that's where you have that.
You could have 2, yes. Or if he had stuck around in Orlando long enough, you could have 2,
Yeah, 'cause the one you bought.
right? Did you have a question, Willie? Yeah.
I thought it had to be like 25 miles apart from each other. I thought that there was a distant proximity requirement with having a dual homestead. I'm sure they're not gonna test that.
Not for this purpose. I'm wondering if maybe for tax exemption. But honestly, I don't know the answer to that question. For this purpose, there's no, I don't believe there's an actual distance. Not that I'm aware of, let's put it that way. Okay, yeah. Okay, so he goes up to Orange County, moves into the condo. If he's stuck around, condo's fine. You can have homestead in a condo. Condo's considered real property. I've never seen him test it, but you can also have a condo in a co-op. And of course, the interest in a co-op is personal property, not real, technically. We don't have a lot of co-ops in Florida, but there is case law that says you can have homestead in a co-op. You can have homestead in a mobile home, too. So it can be, and you can, yeah. So they could get creative. I've never seen them get real creative on that issue, but they could. And just note, by the way, because they do like to test, they love to test property located in the middle of the state where you have lots and lots of acres. If it's up in the rural part of the state, you remember, again, you get up to 160 contiguous. They got to be contiguous. If they're divided, no go. What happens if part of the property is used for the residence of the owner and part is used commercially? That is actually a split of authority on that point. Some courts say that the entire property, even if part is used for commercial purposes, the entire property is still protected because it says the residence and improvements. That's what the Constitution says. And then there are other courts that limit the protection to the area in which the owner actually lives. So we're talking DCAs, of course, the split. The Supreme Court hasn't addressed that particular point. So again, be aware on that particular issue. Okay, so Mr. Adams moves into the condo. He lives there for 2 years. He could have, if he'd stuck around, again, made that his homestead, but he didn't. Now, I see a little typo here. Sorry, I didn't type this. It was scanned, actually. And in 1995, the roof, I think y'all probably figured that one out, of the Miami home needed replacement, and Mr. Adams obtained an unsecured loan, from XYZ Bank to pay for the new roof. You're thinking roof repairs, you're thinking something that grows out of the property, those 3 exceptions that I just talked about. But guess what? It's unsecured. So we'll come back to that point. That's a big issue. And then Mr. Adams moves back to Miami. So we know he has abandoned the condo in Orlando. And plus, he puts it up for sale. So moving back in and of itself might not necessarily be abandonment, but putting it up for sale, you bet. Now, he then dies conveniently or inconveniently in an auto accident in '97. He's got a validly executed will. So you're not going to take time here, fortunately for you, to talk about all the elements that are required for due execution of a will. They've already told you, so move past it. And he devises everything to his brother Bob. Now, I may have mentioned when we did trust, if I didn't, anytime you get a wills and or trust question, if there's a Bob, just give everything to Bob. Bob always wins. I'm telling you. Read enough of these questions and you'll understand what I'm saying. So he devises everything to Bob. And the question is, of course, whether that devise is good. Only assets that we are working with are the condo and the Miami home. They make it easy for you. And at the time of his death, Mrs. Adams and Dot are still in the home, going back to that issue of giving him a homestead in possibly that property, even though he doesn't live there. He's uninsured, of course, and so victim gets a judgment. Is victim going to be able to come against the homestead? Nope. Victim and XYZ Bank file timely claims, so you don't have to go into the procedure. The question will be whether XYZ Bank is going to have a claim, and the answer is probably no. And now, the only part of this question that isn't really modern in terms of question form is the discuss. They tend to be a little more pointed in the call of the question today, as we've been saying all along. But we look at the rights of the parties to the condo and the Miami home. So let's take a look now at how we're going to dissect the question. And notice that first, I'm going to establish the homestead. That's step one. And then second, I'm going to dispose of the property. How are we going to establish the homestead? We got to find out which property it is. And then I threw in here, although it's really not it's not really an issue in this case, procedure for claiming homestead. You don't really have to worry too much about that. But in case you wondered, I've got it in here. So we need a natural person. What do we think about Mr. Adams? Natural enough? Yeah. What they could test, and interestingly, Judge Shepard didn't go there in his lecture. He usually does. He might have been running out of time. The question is, can you have homestead in property held in an revocable inter vivos trust? There's a split of authority on that particular point. And Judge Shepard, if you ask him, will tell you absolutely yes, positively, because that's what the 3rd DCA has held. And in opinions authored by Judge Shepard, so yeah. There are some bankruptcy courts sitting in Florida who have said no. When property is in a trust, the trust is not a natural person, right? And of course, in a bankruptcy case, the court's going to want to pull as many assets into the bankruptcy estate, right? So they're going to pull it out of the trust. What those who follow the lead that Judge Shepard and the 3rd DCA have said, what they say is, think about what a revocable trust is. Who controls a revocable trust? The settlor calls all the shots. The settlor can revoke the trust at any time. The trustee has to answer to the settlor and nobody else during the life of the settlor, and the settlor's creditors can get at the assets in the revocable trust. So there's good logic behind the opinions that say that we should treat it as if it's still owned by the owner, because for all intents and purposes, the law treats it that way. Yes, sir.
This may be a stupid question, but who's claiming it as their homestead, the beneficiary or the settlor?
No, the settlor. So the beneficiary can't, because the beneficiary has no real rights until the settlor dies, right? So it's the settlor who is claiming it as homestead. And 3rd DCA says yes, the settlor, even though the trust is not a natural person, the settlor can still claim the property as homestead. And some bankruptcy courts, again, sitting in Florida, have said no, because a trust is not a natural person. I'm sorry? No, revocable. Revocable. Good question. The question was, is the rule the same for revocable and irrevocable? No, we're talking about revocable only, because an irrevocable trust is outside the control of the settlor, so it's not going to qualify for that rule. Yep. The split of authority on revocable.
Split of authority on revocable, but it's clear.
Clear on irrevocable, you can't claim it as homestead, at least at this point. And I doubt that that will change. It's the revocable trust and the nature of the revocable trust, which makes for a great essay question, which they haven't tested yet.
On the revocable trust, and that's because you said the creditors can still get to the assets of the trust. They don't need to actually
right.
Go after the
as a general principle, think about your revocable inter vivos trust. The settlor can get the trust, can revoke the trust and get everything back anytime he or she wants, number one. Number two, that revocable inter vivos trust is subject to the claims of the settlor's creditors throughout the settlor's life. They can reach that trust at any time. And third, and importantly, again, because it's a control issue, the trustee of a revocable inter vivos trust answers solely to the settlor during the settlor's life. All of those are statutory now in Florida. So think about it. Who's got control? The settlor does. It's really like it's the settlor's property. And so that's the rationale in saying that if it's so much like the settlor's property, we can still find homestead in it.
Oh, yeah.
Okay? It does. It makes sense. We know where the bankruptcy courts are coming from, and that makes sense too. You got it. Okay, so the Miami home, it's within the city of Miami, again, within a municipality, so we know we have to have just a half acre. And remember, this property is how many acres? One. So half of it's protected, the part with the house on it, half acre with the house, and the other part is not protected. because it's within the municipality. Yes, sir.
Overordered property partition.
Yeah.
Some will have.
Yep, that's exactly right. If the creditors are successful, the half that's not protected could be sold. Yeah, I know. Yeah, how do you figure out how to partition?
They're not asking us that.
That's property class, and the court would have to figure out exactly how to do it. And if
If it wasn't there,
if physical partition is impossible, they might have to force a sale. So, but that's way beyond what you'll have to do. But it's an interesting question. Okay. Outside, we know 160, we already talked about that, but we got that condo. It is outside a municipality, apparently. But I doubt seriously that the condo has 160 acres that are contiguous to the condo. I don't know. That's a big condo, yeah. So just to note it. Now, got to be a permanent residence, and the Miami home was clearly their permanent residence while they were living there. And notice, by the way, what I'm doing here. I'm not laying out all the rules over here and then the facts over there. Try to integrate. Take each component, natural person, size, permanent residence, analyze each separately. It's going to make your analysis much easier to see. Question?
Can you remind me, is there a waiting period, or with the homestead qualification?
As soon as absolutely, you do, and you don't have to file anything. You just make it your permanent. Yeah, it's immediate. Correct. And so, of course, the sooner you establish it, the sooner, by doing all these things, the sooner you're protected from your creditors. The home, again, they lived there, and if Mr. Adams had stayed there, we'd be on to the second part of the question. But it continued to be the homestead, as we said before, of the family. He moved away, but he didn't abandon it because his family stayed there. And there is case law on that particular point. And the person who is challenging the homestead has to prove that he abandoned. Tough one to prove in this case. Remembering again, kind of goes without saying, temporary absence. I've seen them test temporary absence before. If Mrs. Adams, for example, goes on vacation or goes to visit her mother for a couple of months, temporary absence, not going to be an abandonment. Now, these are just cases that I list in there for your edification. We know, again, he left, but he left because of the divorce. The family's still there. So I have concluded there's no abandonment in respect to the Miami home. And I even added the roof, not rood repair. It shows that he's trying to maintain the house, right? That suggests he's not abandoning. So use those facts as much as you can. Now, what about Orange County? Oh, I'm sorry, go ahead.
When you look at the abandonment, you look at his abandonment?
Yes.
Or if it's
Well,
family,
it's both. It's both. First, we want to know, did he abandon? But he didn't, because he left his family behind. And then, as I said, if we change the facts up, suppose Mrs. Adams moved to California. Okay, maybe then we have abandonment, right? They might have held on to the house, but if she moves to California, it's not homestead anymore.
as long as the daughter stays.
Well, if the daughter stays, good point. If the daughter stays in the house, then it's still homestead, because it's still family. So that's the question. Orange County, could he have established homestead in the condo up there? Yes, he could have. He moved there, but then he turned around and came back. Moving back is not automatic abandonment, but it looks like he's never coming back because he puts it up for sale. That fact should show abandonment. So I don't think Orange County is going to be protected. Honestly, on the exam, if you're looking at the facts and you think, yeah, it's still his homestead because, well, he didn't actually say, I'm never going back, the conclusion isn't so important as how you get there. As long as you use those rules, do reach a conclusion. They want you to come to a concluding point, though. Now, the 2 homesteads I mentioned, it is possible. There isn't a lot of authority on the point, but here's a place where I've chatted with Judge Shepard, and he says, yeah, it certainly could happen. So if Mr. Adams had stayed in the condo in Orange County, or when he came back here, instead of renting an apartment, had bought a house and lived in that house, and the family lives in the other house, then it is possible that he could have had 2 homesteads, because he owned both pieces of properties. One he lived in, one his family lived in, if that had happened. Now, don't forget, it is a point that Judge Shepard mentioned. It's a little bit of a stepchild because it never goes anyplace in a question. And honestly, I never see it go. Yeah, it is worth a rule point, you bet. I never see it go anyplace in the cases. Nobody ever talks about that $1,000 personal property homestead, except put it in your answer, though. If you have a homestead question, throw it in there, because Chris is right. You get a point or 2 or 3. It can help. You're never going to do anything with it, but just mention it. Okay. And notice that that particular exemption inures to the benefit of the surviving spouse or heirs, because remember, Mr. Adams is dead, but it can go to his heirs, can't go to the spouse because they're divorced, but here it goes to both, because it just says heirs, it doesn't say minor. Right? So Dot and Sam get to up to $1,000. They get to split up to $1,000 in terms of the protection. I mean, they don't actually get the cash. They get other kinds of cash, right? Outside the scope of what we're talking about today, family allowance and stuff like that, possibly personal property set aside. Well, actually, Sam is an adult. He wouldn't get the family allowance, but Dot would. Okay, now notice, and this is for your information. I've never seen it tested, but you never know. Jurisdictions in the circuit court. You'd be surprised at how many essay questions have a little jurisdictional issue tucked away and talking about getting your extra points. Make sure you pay attention to jurisdiction. And make sure they put the case in the right court if they give you a court. There's an old criminal procedure question from some years ago in which they had an information returned to the wrong court. And honestly, I had taught the question a couple of times before somebody said, ooh, you know what? It's the wrong court. Absolutely correct. They like to give you little bits and pieces of stuff like that. If you're paying attention, you get the points that other people don't get. And that can make the difference between passing and failing. Okay, now, what are we going to do with the property? We have to look at the devise of the home in Miami, devise of the condo, the creditor's claims, and I just mentioned briefly procedure for satisfying the creditor's claims. You really don't need a lot of that in this question. Again, there for you as a study aid. So what about the homestead? All right, we know the rule that we discussed before. And remember, we've established whether there's homestead. That's your first step. Now we've got those various categories that we might need to discuss. Don't mix and match. Take each separately. This particular question is, can the homestead be devised? No, if there's a spouse or a minor child. We know we don't have a spouse, but we do have a minor child. So can Mr. Adams, or he's dead now, could he devise whatever his homestead is? No. But he can devise what?
The condo.
The condo, because we pretty much decided that it's not homestead, and if the Miami home is homestead, which I think it is, the other half. Don't forget about that other half. So,
Wait, so the daughter only gets half?
yeah, because a half acre, yeah.
Oh, sorry.
Right?
Yeah,
Okay.
I thought you were talking about something else.
Yeah. Now, and remember, since the, the half acre is what's protected, right? Now, the property can't be devised, so what do we do with it? And if we had a spouse, then the spouse would get the choice of a life estate followed by a remainder, or would share as a tenant in common with the kids. But spouse is gone, we treat her as having predeceased because they're divorced, and so what do? The kids take the 1/2 acre as tenants in common. It's going to be the half acre with the house, however that's figured out. And they aren't going to make you, sit there and draw a picture, so. Question?
Just
No, yeah.
a question I pondered. With regard to, I know it's validly executed will, but if he didn't include the kids in there, couldn't you make the argument that he left them out on purpose?
Even if he intentionally omitted the kids, first of all, they are not pretermitted, right? You got a different set of rules if they're pretermitted, but they were both born before he executed the will, so they're not pretermitted. And if they are intentionally omitted from the will, true, but it has no effect on what we're talking about here, right? Because that's statutory, you got it. The homestead's going to descend by the rules that are in the statute, and the will is not going to affect it. Okay, good point, but remember, keep those two things separate. Anything that he's done, he can keep the kids out of everything else that he's disposing of in the will. He can give Bob everything else. But just not the homestead. Exactly right.
And that's because the kid's under 18. So if the child was
correct.
over 18,
that's correct. The devise of the homestead to Brother Bob fails in this case because Dot is 14. And because Dot is 14, Dot and Sam share the homestead because Mrs. Adams is out of the picture.
Is that because it goes almost like through the intestacies?
It's close to intestacy. It's not exactly like it, but very similar. Because the spouse's role is a little bit different from the spouse's role for intestacy, but yes. Question?
Yeah. It was just Dot's minority kind of works for Sam.
Yes, it does. Sam gets something here that he might not otherwise get just because Dot is a minor. Absolutely correct. Yeah, he gets to share with Dot even though he's an adult, and he gets to share because she is a child. Yeah, so he's freeloading a little bit here perhaps, but yeah, he gets the benefit. Absolutely correct. Oops, I'm sorry. Susie, we are done. You can clean this stuff up. Anybody else want earplugs before Susie takes them up? We're all good. Brian won. Here's our winner. And you need that. And you can probably take the packets, yeah. Everybody has a packet, right? And even though we're not completely done, and Sarah's not here, so we'll have to thank Sarah next time. Please thank Susie. She's really done a yeoman's work. All this stuff that goes on behind the scenes, that's Sarah and Susie. Okay. What if tenancy by the entirety? I would not include a discussion of tenancy by the entirety in this question if I were writing the answer, because it clearly is not a tenancy by the entirety. But I want to point out what happens if the property is tenancy by the entirety, because people get kind of confused. That's why I threw that in there. Suppose that Mr. Adams inherited the property, as he did in this case, but then, by deed, he created a tenancy by the entirety with his spouse. Now they are true tenants by the entirety. That property is still subject to homestead protection. So that, that prong dealing with protection from the owner's creditors, that's still there. But the rules for devise and descent don't apply because, of course, it's a tenancy by the entirety. So the survivor gets the whole thing. Exactly right. Yes, sir.
But still gets the protection of the creditor.
Wait, we got two people going on? Okay, is this the same? Yeah, go ahead.
Divorce not affect that?
Oh, right. Leave the divorce out for a second. Absolutely. If they're still married, should have qualified that, absolutely. That's what I was thinking, didn't say. If they're divorced, of course, they hold how? Tenants in common. So then you're back to square one. But if they are tenants by the entirety and there's no divorce, then the survivor takes the whole thing. The rules of devise and descent don't apply. It's still homestead, and you apply the rules for protection from creditors. But you don't apply, again, the devise and descent rules. Okay, Orange County. I'm giving everything to Bob. I don't know about you, but I'm giving everything to Bob. We kind of talked about Orange County. It's not homestead, so the devise to Bob, I think, is good. Whatever you conclude. Don't forget about family allowance. I don't know, honestly, if they were really looking for a discussion of family allowance, but the call of the question is pretty broad. So remember, with the family allowance now up to $18,000, and it can be claimed by the spouse, but we don't have a spouse, and any lineal ascendant or descendant that the decedent either was obligated to support, that's Dot, or actually supported. Well, he didn't support Sam. Sam moved to Wisconsin. I think that's part of why they had to move. So who gets the family allowance? Dot does. And it is, remember that we talked about a couple of weeks ago, it's Class 5 claim. Question? Somebody had a hand up. Yes, sir.
Would it go to her under trust because she's a minor, or does she get it?
Well, not in trust, but to a guardian for her. Okay? That's I don't think, could they test guardianship? Oh, who never knows. It's not, I would hate that they would, but I wouldn't worry about it. Yeah, it would be through a guardianship. And I don't think you're going to have to worry about it. I don't think. Don't kill me if you do, though. Okay, now, remember, Mrs. Adams can't claim, Sam can't claim, Dot gets up to $18,000. Exempt personal property set aside. A little bit of review here. They don't give you a lot of facts to work with, but remember, up to $20,000 of all that stuff. And they changed the rules. It used to be all the cars that you could own. So if you had, as my uncle used to do, like 15 cars sitting out in the driveway. Nice. Yeah, Mustangs, he had great cars. 2 automobiles, up to 15,000 pounds. That's still a pretty big motor vehicle. Got to be in the decedent's name, has to be regularly used by the decedent or family members, and it's got to be personal use. And so Sam and Dot, here we don't limit it to the minor for the personal property set aside. Of course, it would have gone to Mrs. Adams, but she's divorced. Now, claims of the... I'm sorry?
On the cars.
Yeah. No cash value, right. Interesting, yeah. It's a screwy kind of rule, I think. It's just how big is it? And I'm not real up on automobiles, but 15,000 pounds sounds like it's pretty big. You know, maybe not.
Half-ton truck is 3,000 pounds.
Yeah. Yeah.
You know why that's so heavy? I talked to Judge Shepard about this. It's because of the history of Homestead and it being from farming. So the vehicles are an extension from tractors.
Yep. That makes sense.
Or hauling trucks, you know, to haul
okay,
hardware.
Makes perfect sense, yeah. Many of the rules that we have in Florida, here we sit in South Florida, and we look at these rules and we kind of go, huh. They are rules that were developed for the rest of the state, agricultural state. And even, you know, we have agriculture if you go farther south from here. And yes, so that's a good explanation that Judge Shepard gave. Now, we have potential creditors. We've got, besides Dot, we're going to leave Dot aside for now, we've got the bank and victim. So, Orange County Condo, go to it. If they file properly, which apparently they did in this case, they can go right after that condo. Homestead, though, it's protected. And we have 3 categories. which I don't have up there, but the 3 categories we had before, and those 3 categories, they are all claims that grow out of the property itself. Taxes, mortgages, and then the 3rd category, which is labor, workers' mechanics liens. So it's for labor actually done on the property, contracted directly. And that's the problem in this case, because it wasn't contracted directly. Victim's not going to fit in any of those 3 categories, so no go. The question is bank. Nope, there are the categories. Bank cannot, there's no mortgage, right, because it's unsecured. So obviously it's not taxes. Bank can't fit in the 2nd category because the loan wasn't secured. It was money that was given by the bank to Mr. Adams to fix the roof, but it still doesn't fall in that category. And that's because it wasn't contracted directly. It's just money they gave him, and then he went and hired the workers. So you had that extra step in there, and so the 3rd category is not satisfied in this case.
So if this was a home improvement loan?
Home improvement loan, it could, not a home improvement loan, whose claim goes in?
Oh, the roofer.
The roofer. Exactly right. Okay? Now, home improvement.
So why doesn't it fit into 2 though?
Because it was unsecured.
Okay, no mortgage.
No mortgage. A home improvement loan that's securitized could fit in 2 easily. And the roofer can fit in number 3. But a loan to Mr. Adams to hire the roofer, the bank isn't going to fit in 2 or 3, at least in this case, because the loan is not secured. Yes, sir.
For the roofer to fit in under the 3rd one, do they have to file something before his death, or they can file it anytime?
They can file it.
Yeah, oh, you mean the mechanics lien? Yeah, no, they don't have to.
Actually, you want to know the actual answer to that? They
Okay.
have 90 days
Okay, good.
from the last day on the job site or materials delivered to the job site.
Thank you. That's a rule I didn't know.
Valid for 1 year
Okay.
until they enforce it.
Okay, so it doesn't have to do with his debt, but it has to do with the completion of the project. Now, in the material, I have a couple of cases about equitable liens, and it's something actually I've discussed with Judge Shepard as well. There's all this case law out there, but you know, it's a tough one. It's very hard to prove an equitable lien. I'm not sure I would actually go there in this question, but I give it to you to sort of think about, because if there was some kind of fraud involved, if Mr. Adams was trying to defraud the bank, I don't know how, but in this case by not giving a secured loan, then maybe they could have an equitable lien. Highly unlikely, but kind of an interesting subject, I think. And that's what all of that is, so I leave that for your reading pleasure. Now, just the last stuff I'm also going to leave for your reading pleasure is a review of the procedure that we talked about a couple of weeks ago, when a creditor has to file and how that process goes. They did not ask about it in this question. They just said the claims were properly filed. And so I would not include it in my answer. I gave you a little bit here, just again, as a review tool.
Just one twist on this. Jail. How does that affect homestead? If the homestead goes to jail, gets indicted or whatever, goes to jail, and they say, okay, yes, if obviously life imprisonment is going to be abandonment, but if it's
OJ. OJ.
Right, exactly. He homesteaded all of his property, dumped all of his money in there, but they weren't able to get to the money.
While he was there, the house has been sold now.
Oh, because once he got taken to jail?
Well, no, he didn't technically abandon when he went to jail, because he didn't go voluntarily, did he? But
Right.
and he had 2 kids there, yeah. But they have now sold the property, so it's a non-issue. The question is, if you are incarcerated against your will, have you voluntarily abandoned your homestead? No.
No.
Yeah.
And then I thought of it because of this.
Yeah.
So I would think a court would maybe violate a homestead exemption in a case like
Well,
the guy gets a death penalty and has a bunch of money and owes the civil people the money, they're gonna.
there's your,
say
then you
justice.
could, there's your fraud, your equitable lien, possibly, yes. And yeah, if if that house was still sort of sitting there, hiding all of his assets, maybe. But, yeah, I could see it in that case. That would be an exception, not a rule, though, on that particular point.
Yeah, so technically that, even you go to jail, you don't lose your homestead. 'Cause
Not- yeah.
Your argument, either your family's there, or you could.
You're coming
eventually
back, right?
Sometime return.
Yeah,
Maybe
right.
the laws
It's-
would change, you could get out,
Well,
you could get pardoned.
here's the
You're not gonna
point.
stay in jail, right?
Yeah, it's what your intent is, right?
Right.
And if you're involuntarily incarcerated, your intent is still to go back, I would say. Honestly, I haven't seen any case addressing that particular issue, but a short stay in jail, it's not going to be an abandonment, and
Oh, yeah.
and even if he goes to jail, gets paroled, right? I think usually not. Again, I have not seen a case on that particular point. There could be, that I just haven't seen it. Yes, sir.
I mean, also, if he goes to jail, but has like maybe, I don't know, somebody help out with him, like maybe a relative or something, and he tells them to, hey, fix your roof.
Yeah,
or something like
it
that.
shows that he's not abandoning, right? Yeah,
As long
because
as somebody's paying the
yeah,
taxes.
exactly. Yeah,
So that
exactly.
they don't come back.
Yes, sir.
There was a slide like 20 slides ago that had. It was about like jurisdiction and because you're talking about.
Oh, yes.
homestead. But then on the bullet underneath that, it said, you go to the circuit court, you file this thing, and whatever. Now, you mentioned that, if certain like factual elements
Mm-hmm.
are satisfied, then you qualify for homestead protection. Why then would you file anything with the court? Is that just something that you can do in order to receive like a judicial declaration?
Yeah, exactly.
or
You
something like that?
you can do is the answer. You don't have to. And quite frankly, when it comes to everything except the exemption from taxes, because then you do have to file, it usually comes up when you have a lawsuit. No, and
You can use it as an affirmative defense.
Right.
Submit it as.
Right, exactly right. So you do not have to file to establish homestead for these purposes. You do for your tax exemption, that's clear. But for these purposes, can you file? Yeah, but you don't have to. Exactly. And if you do, then you go to the circuit court. Okay, let's take, let's take a brief break. Well, I'll get you out of here by 6 because the last thing we have is the family law question, and that won't take so very long. So if we can come back by, say, 5 o'clock, we'll be out of here by 6. Uh-huh.
The other day. If I go to your house and you're a wine cellar, that locks automatically. But there's a button I can press for you to let me out. You tell me to go down there, you let me out, whatever. Somebody else comes into the house, knocks you out, and then I'm stuck in the cellar.
False imprisonment, is that where you're going?
Yeah, is that third party, there's no intent there? 'Cause
Yeah.
I know, that's
Yeah.
what,
Yeah.
Does transferred intent apply there? For different, toward different?
Let me think about that for a second. Could you do transferred intent? In that case, I got that. It's good, interesting question. I got to think that one through.
Or shell doctrine, but that's.
Oh, that's different.
too far.
That's too far-fetched. Could you use transferred intent for? All right. Thank you all very much. Let's go ahead and get started so that we can, I'll get out of here. Okay. Take the family law question, spend a few minutes. It's a short question. And same thing, pick out some issues, and then we're going to break it apart. right, so let's see what we have here. I want to kind of make one comment before we jump into this particular question. What haven't they hit yet out of the new subjects? Dependency, which I think could easily be combined with family law. I actually kind of thought they would have already done that. There's no question, obviously, that we can do that combines dependency in, but I think it's going to come. So kind of be on the lookout for it. I really do think you'll get a family law question this time. The good news is family law is pretty easy to write about unless they dump something new in, which would be the dependency. How you write about dependency is kind of hard to say because we don't know yet what they're going to ask. But what I like about this question is it just kind of marches you through the typical issues that they hit. And you can form your answer around the structure that we're using here. And most family law questions, with maybe a little bit of jurisdiction thrown in, most family law questions are going to follow this format. Now, as we go through the facts, just a caution. If you've had a personal experience of any sort, don't bring it into your answer, all right? And, you know, as we go through, usually I can kind of draw a line through the middle of the room, and the women on one side, the men on the other, and, you know, that's how the answers tend to go. Try to be as neutral as you can in analyzing the situation.
Listening to the child.
Yeah, well, don't say it every paragraph. Okay?
Guarantee that point.
Yeah, but you know, I promise you, if you say it every paragraph, which some people do, you're not going to get a very good score. And the reason that, you know, remember your grader is looking for somebody who can be a neutral and detached lawyer. And I read these essays. People send me essays to read all the time, and it just, the vitriol that comes out in family law questions is amazing. All right, so we have husband and wife. They met in college and married after graduation. We don't know yet. Eventually, of course, they tell us they're in Tampa, Florida. But remember what I said before. If it's an essay question, unless they specifically say use federal constitutional law or federal criminal procedure, if they don't exactly tell you where it's located or you know, what law to apply, say, I'm going to presume it's set in Florida and I'm going to apply Florida law, because that is what they're looking for. Husband attended medical school while wife worked in the local department store. Now, this is an older question, and it reflects things as they used to be. Now we have equal opportunity. Could be the husband who's in medical school and, the wife who's in medical school and the husband who's working to support. But the fact of the matter is that one spouse in school and one spouse working to support, that is a fairly common situation. And so you know what's going to start to unfold, because in this case, she works, she puts him through school, she takes care of the kids, she takes care of the house, and then as soon as he gets out of medical school and gets a little bit of money, he divorces her and then moves on. A fairly typical fact pattern. Now, look at some of the things that are in this fact pattern, and that's why I say don't, you know, let your own personal experiences color what's going on. Husband paid his medical school tuition by withdrawing money from a trust fund which husband's parents had given husband before his marriage as a graduation gift. That trust fund is, fill in the blank, non-marital asset, right? But he buys the house, and the medical school tuition, I'm sorry, before we get to the house. Medical school tuition, what about a professional degree in Florida?
Can't touch it.
Not marital asset, okay? It's not an asset. But remember,
It's not a liability either,
right, it's not. But in New York's the only state in which a professional degree is a marital asset. However, don't forget about goodwill, though. Goodwill, quantifiable goodwill, can be a marital asset. I've actually never seen them test that, but just, you know, the kind of little things to look for. Now, husband's trust fund had $500,000, and then they buy a $200,000 house in Tampa, Florida. Well, it's a little on the vague side. They buy. Tenancy by the entirety. What's, you know, I'm presuming a tenancy by the entirety, and that's how my answer is going to go. I'm sorry?
Well, doesn't Florida presume it if you have
Well,
three
if
couple buys?
If they take the deed together. The fact pattern isn't as clear as I would like it to be, but I'm definitely going with tenancy by the entirety here. And now it's in Tampa, Florida, so we know we're using Florida law. If there's money from the trust fund, do we care if they use money from the trust fund to buy the house?
Yes.
No. It's still a marital asset, and I'm going to explain why.
If you deduct it from the trust fund money that the
Well,
husband would keep as a non-marital asset?
Correct. The 200,000 is already out of the trust fund for sure. But what we're going to see, there's again, when I pick these questions to use, I always have the benefit of time to do a little research, and so I actually research the questions. And most of the time, I can find a case or cases on which they base the question. And there is a case, which I've got cited in the packet, that is the model for this part of the question. And if one spouse buys property, puts it in the name of both spouses, that spouse who uses his or her own money is presumed to be making a gift to the other spouse.
Oh, okay, so it becomes marital property.
Becomes marital property. Yeah. Okay. Mortgage payments and taxes were paid by husband's trust fund. Now, the fact that they're using the trust fund doesn't make the house a separate asset. It just means you've depleted the trust fund. But of course, wife is putting in money she gets from her job till she quits the job and stays home. So, you know, the money that goes into the pot is part of the marital operation. But of course, that money's no longer a marital asset because it already got spent. Wife paid all other living expenses. So they're both contributing, and of course we've got statutory factors that are going to look at the contributions of both spouses to the marriage. 4 years later, he graduates, he begins a residency, she quits her job, stays home, raises the 2 kids. She's still contributing, of course, her services as a homemaker are valued and valuable. But that, again, it's a factor that will be considered in a couple of places in our analysis. Husband, of course, he's a successful doctor. He works long hours, doesn't spend a lot of time at home. Why do they put that in there? No, not in this case.
No, best interest of the child.
Oh, best interest of the child, yeah. Question is when we talk about the shared parental responsibility, that could come into play. Now, for their 15th wedding anniversary, when this question was written, the fact that it was the 15th wedding anniversary was kind of a non-issue. Today it matters because 15 years? Intermediate, yeah. So we've had a change, but I still like this question because it adapts to the new rules. Husband bought wife a $40,000 sports car. The car is a what? Marital asset. Interspousal gift. It's a marital asset. So if you didn't know that rule, make sure you do because they love to test interspousal gifts. She appreciates the car, but she really wanted husband to spend more time at home. Well, that's sweet, but why do they put that fact in there? Anybody know? It's a marital asset. And with a marital asset, what do you do with marital assets? You split them, but what are they going to do with the car? You're going to sell. No, she doesn't want it. Sell it. Well, now, you might want to keep it, but she didn't, so they'll sell it and they'll split the proceeds. But if one spouse wants an asset,
They'll let them have it.
they'll let it, and you got it, exactly right. So, and I've seen cases, especially involving homes, where one spouse wants the home. It's like a lump sum. They give the spouse the home and then make up the difference with the other spouse in terms of cash. But here, she doesn't want it. That's why that fact is there.
That's separate from alimony.
It is separate from alimony, correct. Absolutely correct.
But it could be lumped together in payments, right?
Yes, that is true. Now, unfortunately, husband's absence from home was due in part to an adulterous affair he was having with nurse. Oh, Lord, yeah, right?
It's still best interest of the child as well, because
The affair doesn't affect, it doesn't affect equitable distribution at all, because the statute doesn't even address it in the statutory factors. There is a statutory factor for alimony, correct, but despite the fact that the statutory factor is there for affairs in respect to alimony, what the courts have done is graft back on that requirement that it deplete marital assets.
Oh, yeah.
Oh, yeah.
You could do wasting the asset.
Yeah. So again, that's case law. There are statutory factors for equitable distribution, for alimony, and for parental responsibility. There's no reference to an affair in respect to equitable distribution. There is a reference to an affair in respect to alimony. But old case law, prior to the change in the statute, said for both alimony and for equitable distribution, the only time you take an affair into account is if it depletes marital assets. That case law has been grafted onto the statute in respect to both, really. So the only time still that you're going to take an affair into account is if it depletes marital assets. They didn't give you that fact here. But you would want to say that that's still the rule.
What it appreciates marital assets, he was at work more.
Oh, well,
It doesn't matter, it doesn't work like that.
it doesn't matter, yeah. And the only, the only reason, once upon a time, there was something called a special equity in Florida. We don't have it anymore. And maybe you could have a special equity in that case, but it's a non-issue because we don't have special equity anymore. Yeah, yeah. Okay. Shortly after their 15th wedding anniversary, again, why I like this question, it's an old question, but now 15 is relevant because it's an intermediate length marriage. Wife discovers the affair. She files for divorce, of course. And husband and wife are 37. Why do they tell you that? Okay.
Career.
Right. There are a number of things, but one of the things we look at is in respect to alimony is the health and stage in life of the spouses. Daughter is age 11 and son is age 8. I think those facts, those ages are actually very significant. Why are they significant?
Because she still has to stay home and support the kids.
Well, yeah, but a girl who's 11 and a boy who's 8.
Oh, they can, yeah.
Because the children, when we come to parental responsibility, the children can voice their preferences if
they have, if they have the ability to understand.
They have the ability to understand who they would like to live with or how they'd like to. They get to voice. It's a factor. There's no absolute line, but it's a factor. Now, a girl who is 11 probably is mature enough to voice a preference. An 8-year-old boy, sorry guys, girls develop sooner. Yes, but that's why I say and it's a fact of life. It's just the way it is. Girls develop sooner than boys. And so the ages, I think, were put there for that reason.
And then also best interest of the child.
Absolutely. You like best interest of the child. I can see that, Chris. Okay, now, look at the call of the question. It's one of the reasons why I like this question.
Yeah, it breaks it down.
It says, distribution of property, alimony, child custody, well, it should be parental responsibility now. It's an older question. And child support. It breaks it down. That's the order that the statute tells you to discuss these issues in. You're supposed to distribute the property first and then award alimony. Statute specifically says that. So that's the order you should go in. Now, occasionally, it's interesting. Occasionally I've seen questions where they change the order. If the call of the question changes the order, follow the order in the call of the question because that's how the grading answer is going to be organized. But if there is not an order stipulated in the call of the question, it's the order you want to use. Okay, so let's take a look now. Once again, I have a lot of extra stuff thrown into the question because in starting with antenuptial agreement, there isn't one here. But just to remind you to think about it, I would not in the question actually take the side trip into a pre or a post-nup agreement. But just so you can read this, I'm not going to go into it now. Make sure that you're, I'm sorry?
They're about full disclosure.
Yeah. Right. Just, that's good enough, probably. Yeah, it's honestly for this. Unless we're talking about a waiver of statutory rights, which is a different issue. marital assets. Now, on dissolution, in Florida, where Chris wants to say best interest of the child every place. Here, we say Florida is an equitable distribution state. Okay, say it, right? Because we're not a community property state, so make sure you say equitable distribution, right? Buzzwords, there are a few other buzzwords we're going to be talking about that you want to throw out there. That's one of them. And equitable distribution is going to be equal unless treatment can be justified, or unequal treatment can be justified. There is case law that says equitable distribution, just divide it down, and it's very clear, divide it down the middle, 50-50, and make up inequities in alimony. So, yeah, I would recommend as you write your answer, just divide. Now, you're going to consider the statutory factors. You really want to go through them. But when you write your answer, just 50-50, and then whatever you need to make up for, in this case, the wife, you do through alimony. Yes, sir?
If in the fact pattern, they're kind of vague on the value of the assets, like, we kind of just make it up.
Well, yeah.
Even yesterday,
Yeah.
said that the only asset was the home.
I know, yeah, which, you know, they got something else, right. I wouldn't make up a whole bunch of stuff. I would focus on what they give and say whatever other assets there are.
But I'm just saying about, how do you
Yeah.
make that equal? I get you could sell it and split it equally,
Yeah,
but
yeah. They look at this question. They give you a home, they give you a trust fund that's not a marital asset, and they give you a car. It's a sports car. I mean, these people must have other stuff. They got kids, you know, they probably got a couple of cars. They've got other kinds of things. I wouldn't make it up. Exactly. That's what I'm saying. They gave you assets that they wanted you to talk about, and I would limit the discussion as much as possible to what they gave you. Clearly, this family has other stuff, but they didn't want you to talk about the other stuff.
no, I'm not saying like make stuff up, I'm just saying, how do you possibly, if you, all you say is, all I have is this car and this house. Well, what if you don't know that the house is worth 200,000, and they're telling you, and I'm saying, well, you should divide it equally. That's it? Divide it equally, figure it out.
Yep, exactly. Because if they, a couple of things on that point. First of all, they aren't wanting you to get into heavy-duty math because they haven't given you any numbers to work with. And remember, that's one of those things you can't take in. You can't take a calculator in, right? So they really aren't going to make you do the math. Divide it equally, you're good.
So, Dean, you said don't address the equitable distribution unless you said just address the equitable distribution and then
First.
the difference.
Equitable distribution it should be addressed first, always, because the statute says it should be. But what I said was that, notice what the statute says, distribution must be equal unless unequal treatment can be justified. In reality, if you look at the cases, very consistently, the courts just go 50-50 on equitable distribution, and any difference that they need to make up, they do through alimony.
But on the essay, is that how we approach it, or do it unless, though? We're doing that.
No, don't go into the unless. You're going to see what I do here. I just divide everything 50-50.
Okay.
Even though the wife needs some extra stuff here. I make up the difference in the alimony, right? I'm not going to say there's never a case where unequal distribution is justified, but under the current statute, it's not going to be the norm. So I would just go with the norm here. It's much easier to answer. Yes, sir.
I know it's not an issue in this case, but with respect to antenuptial agreements, is there a presumption that it's validly executed if someone's claiming to enforce it and say it? Because I mean, my Barbie book was kind of confusing. It just says like a spouse claiming validity of an agreement must establish a fairness of the contract. So they have to establish that it's fair.
Yeah, it does have to be fair.
So it's like a presumption against it until.
Well, I wouldn't say it's not a procedural presumption, right? It's just something that you have to prove. So it doesn't work like the bursting bubble or the burden persuasion shifting that we talked about before.
Okay.
But you have to prove the fairness.
Okay.
Okay.
But it said that, maybe I'm wrong, but it said for post-nups that basically, as long as it's a valid full disclosure, and the person has informed consent,
Well, that's
it's going to be valid. Consideration is needed, but is the promise.
The
to stay
promises
married is in
are
there,
the consummation, yeah.
or consummation. So really,
Yeah.
if it's a
barring any type of like fraud or duress, those are the red flags that they said to look for?
Yeah. Honestly, I've never seen a question where it was a debatable issue.
Right. If it says they did a valid, you just say,
Yeah.
okay, she waived all her rights.
Exactly. Just something to think about again, just to be aware of. I wouldn't get too worried about the details of it, to be honest, for that. Now, marital assets though. Now, I've listed everything here. Again, I'm giving you more than you would need. Do try to remember what constitutes a marital asset. In this case, you could probably get away with just saying which, the items that we have are their marital assets because. But of course, anything that either spouse acquires during the marriage except by gift, bequest, or descent. And the trust, remember, was acquired before the marriage, so it doesn't, you don't even trigger that one. Enhancement in value, I've seen that one tested.
Yeah.
They do like to test enhancement in value. Even on separate property. Yeah, there's one question. Yeah, yeah. If the person helps, exactly. One question in particular, there was a house that was separately owned, but I think it was probably the wife. Somebody landscaped it and did improvements, and so that enhanced value.
We just had one like that this week. But it was like he owned a doctor's office
Mhm.
and he owned a practice. So all the time he took away from the practice, like from the marriage to the practice, was depreciation. So she got
That's the
depreciation
goodwill.
in
I have
value
multiple choices.
for
Yeah.
the
The goodwill
his
of the
medical
business.
office.
Oh,
That's the goodwill of the business.
that's the goodwill, which can be a marital asset, yeah.
Okay,
Right?
so that
She
would be
allowed him to do
depreciation.
that by being a home.
Right.
If quantified.
No.
If quantifiable, of course. But, yeah.
Wait.
Well, the goodwill is an appreciation in of the asset. I mean, goodwill, you can't have goodwill if you haven't been out in business for a while. Goodwill is the value that you can assign to your customers and your reputation in the community, which is a form of enhancement in value, but it is as quantifiable. It's something you can put your finger on. Interspousal gifts, of course, we already talked about, which they love to test. And notice what I've done. This particular question, I have a lot more filler than I do on other ones just because there's so many rules that are easy to cite. And again, it's there for your study purposes more than it is for the answer. But anytime you hit something like the car, try to relate the rule to the fact as closely as you can. Because again, a bunch of rules over here. In fact, what you don't want the grader to have to do is keep going back and forth. Because the grader's, especially on an exam like this, the grader's not going to do it. So try to keep your rule and your facts together. Retirement benefits during the marriage, that we don't have any here. Property held as tenancy by the entirety, which we probably have here. And again, I'm going to presume that it is tenancy by the entirety in this case. They don't give you a lot to work with, but I have a feeling that's what they wanted you to talk about. And there's the case that I mentioned, that I found, Robertson versus Robertson. So it's very clear. The case is so similar to the fact pattern that we have here. The husband in that case took non-marital assets, bought a house, titled it in both names, and then said, no, it's my sole property. And the court said, no, you made a gift. And here, there is a presumption. The court did talk in terms of presumption, the presumption of a gift. And the presumption of the gift comes from the fact that the property was titled in the name of both parties. Rebuttable presumption, though, of course, in Florida. I don't think there's very much to rebut the presumption that a gift was intended in this case. So I think the house is marital property.
How could you rebut it if you put it in?
Yeah, that's hard. That's basically what that case said.
Duress.
Yeah, duress. Well, the husband was trying to walk away with the house in that case, and he didn't get very far, let's put it that way.
It's too heavy.
Okay, yeah, too heavy, yeah. Non-marital assets, okay. Anything you get prior to the marriage, and if you exchange for something that remains separate, of course. So it doesn't automatically become a marital asset just because you do the exchange during the marriage. But the trust fund, clearly, the fund itself, whatever's left in the fund. And I honestly, you'll see, I didn't spend much time doing the math on the fund because I'm not sure how much is left in it at this point. Husband's paying some taxes. We know 200 came out, but other stuff came out. The college, the cost of college, probably he's probably got 25 cents left at this point. But anyway, whatever's left, that's a non-marital asset.
If and this is outside of it, but if the wife helped appreciate the trust by managing, say, the stocks or stuff.
Then the appreciation.
The commingled amount, not the.
Not the base. She gets the appreciated value,
Okay.
but the base remains his,
Okay.
right? Because she's contributed to the increase in value.
I got you.
Yeah.
She has the whole appreciation value.
She splits half.
She gets half. The appreciated value is a marital asset, which is then split. She gets her share of the appreciated value. Yes. Okay. Non-interspousal gift, we've already kind of covered that. And of course, anything they exclude, which wasn't the case here. Now, these statutory factors. I know. At least say there are statutory factors. You need to say that much. Can you recite them all? I can't even recite them all. But look for facts that make you think about the statutory factors. That's all you really need to do, right? I have them all listed here, just again, as a study tool. I would just list the ones that match up to the facts. And why? Honestly, in my case, it would be because I couldn't do the whole list. I don't teach family law, except in the bar prep. Some of your family law professors probably could recite the whole list. I can't. But I know what to look for, and I would pick them out and kind of match them up.
Should we include all of them in asset, all the factors?
Do you know them all? If
But,
you,
like, just in general, like for other things too, like for
Yeah.
alimony or like.
yeah.
child and stuff.
You know what? It's interesting. In this particular area, and I don't know why, because I'm not a big proponent of telling everything you know. But you're going to see when I get to alimony, I did just throw it all out there. For some reason, especially with alimony, it's begging for a complete description. I don't know why, but that's one place where I would break my own rule. And here, there's nothing wrong with listing all the factors if you know them all. I guess what I was trying to say is for most people, myself included, I probably could not sit down and write every factor out and get it right. But I can pick them out of the facts. So you're not going to hurt yourself by listing them all, but make sure as you list them, you match them up with the facts that are given.
The list is not exhaustive, too. So if
Yes.
there's something that you could think of.
There's a catch-all. Yep. Yep.
There's something you can think of.
You can toss it into the catch-all. Exactly right. So notice, though,
So that line would be like, the courts look to a consideration of factors, any other factor necessary to do equity and justice, as an example.
right. Well,
Any and all.
any and all, yeah. But we start here. Look what we can start with. Contribution to the marriage of each spouse, including contributions as a homemaker and an educator of the kids. That one, it's in the facts. And so even if you couldn't remember, the facts are telling you. You could guess that it's a factor, right? And clearly, husband is contributing money, but wife is keeping house. She's taking care of the kids, driving them to school, whatever else. So it's a factor that the facts will jog in your memory, if nothing else. Economic circumstances of each party. And of course, that one's easy here too, because husband's got everything and the wife has nothing. Duration of the marriage. You should remember, especially now, because the statute has changed. Duration of the marriage, 15 years, which of course is a factor for equitable distribution, but really won't affect equitable distribution, clearly will affect alimony. Interruption of personal careers. Again, see, these are all things that the facts are going to want to make you talk about. And we know, wife, probably smart on her, I was just going to say, probably smart on her part. She said, no more law school, right? And you're all thinking, that's a good choice now. But yes, sir?
Yeah, but that could also be construed as she has the intelligence and the capability so that when you figure out alimony, you don't have to do like permanent alimony.
You can take it into account, certainly. Okay, but you know, when we get to alimony, we're going to talk about rehabilitative, because clearly, if she's dumb enough to want to go back to law school, she's going to get rehabilitative alimony. And remember, I'm sorry. Yeah. Yes. Yeah. It's optional when you're in intermediate. Yeah, which we'll get to in a moment. Absolutely correct. Contribution of one spouse to the personal career of the other. Well, we know. She quit her job. She put him through school. And it's a factor. New York's the only place that says, okay, that means the career is actually a marital asset. Here, you just use it as a factor in determining. And this one's particularly important in this case, desirability of retaining any asset as free and clear from interference. What we're going to try to do here, of course, is maintain the marital home while the kids are still underage. And so let's get there. Right there. Okay. It's a factor that's actually listed, but even if it weren't, and you just tried to bring it in kind of one of those vague catch-all sort of things, get it out there. Because clearly, and they like to test this particular point, clearly if you have a house, kids have to live someplace, right? And so what they'll do in this case is they'll maintain the house, and then since neither spouse has asked for the house, sometimes they give you a fact pattern where the spouse asks for the house. Since neither did here, when the youngest, the boy, reaches 18, then they'll sell the house. Okay, we get to say it, Chris. Best interest of the child, to remain in the home, which we know because they're kids. And financial feasibility, which makes perfect sense. They can afford 2 homes because husband's making all this money as a medical doctor.
Probably negligent doctor. He's too busy chasing his nurse around.
Well, see, that's where you don't go.
Just throw that into some public policy.
Yeah, it's where you don't go in this question, right? Oh, yes. Okay, and then of course your catch-all. And notice the affair is not a factor for equitable distribution. As I mentioned before, we do bring in dissipation, which we could tie to the, not in this case, but in other cases could tie to the affair. Okay, so what am I going to do in this case? Husband gets to keep whatever's left in the trust. Car, marital asset, sell it and divide it up. And the house, as I said, we're going to maintain it for the kids until the boy reaches 18, and then we'll sell it.
Oh, you don't put the practice in there at all?
Because it's not a marital asset, right?
Right, but I mean, you don't throw that in there and say because it's a
you could.
professional license that's
You
not
could.
attached.
You could. Yeah. I don't have a problem with that. I'm so programmed to think that it's not that I didn't even mention. But yeah, you could easily. Okay. Of course, subject to modification.
Sorry. If it's not a professional license, like it's a painting business.
Yeah.
Does she get half the painting business?
Not automatically.
None of that.
No, if she's not participating, no. Not the business itself, right? Now, if she participates in building the business, we got a whole different ballgame, or helps with the goodwill or something like that. But the business, if it's totally separate, it's not a marital asset. Okay, so alimony. Now, once again, I got everything all listed out here. It's the one area where, as I say, I go against my own rule, and I don't know why. My instinct is they really do want you to spit all this stuff out if you can. And I'm not a big fan of it. Spit out as much as you do know, though, in this area. So, relatively recent changes in alimony, and even though the legislature keeps trying every year to change these rules, there haven't been any recent changes. I don't know what they're going to do in this session that's coming up. You won't have to worry about it. But right now, these are the rules. And so we've got bridge the gap, rehabilitative, durational, permanent, or any combination of the above. Notice that I don't have the temporary up there. It's not part of the statute, but yeah, it's not in the statute. But by all accounts, it should be available. So I actually address it a little bit later. What I have listed here is what the statute says. I'm sure that they did not intend to eliminate temporary alimony. It's just not in the statute. I don't know why. But there it is right there. And I can't imagine, which is the good news, I guess, for you, that they're going to test the old provisions. Whatever is going to, you're going to be tested on, it'll be for a divorce that occurs after the effective date of this statute. Okay, so without going into a lot of detail, I've described them all. I certainly would try to define them if you can, what the purpose is. So remember, if you say bridge the gap, okay, you got a point there, but say what it means, you're getting more points, and then apply it to the facts, you get even more points. So bridge the gap, and it's to help somebody with short-term needs. What do we think, wife here?
Not bridge the gap. She's gonna get durational or.
Well, the judge can combine as well, so he could do.
Yeah, he can. Yeah, see, and you know what? Here we go. We're getting a lot of different opinions, and that's okay. Because she gets to give her the sports car, yeah. The important thing here is not do you give it to her or you don't. It's going through the process. Honestly, they don't care here whether you give it to her or you don't, and you're all going to come up with different combinations because you can under the statute. That's okay. Just address it. Remembering, of course, bridge gap is for no more than 2 years. Rehabilitative. Okay, take a vote. How many want to put her through law school? Give her the.
I mean, what if she doesn't want to?
Right. Now, remember, a change in the law here. Of course, it's her option, and she gets it only if she goes back to law school, but she's got to make a plan. The new statute's very big on plans. There we go. Specific and defined plan. Yes, sir.
If you send her back to law school or whatever, she's not going to be able to watch the kids. So then would you have to compensate with daycare payments or babysitter?
Well, right. It doesn't. Any kind of school, right? Yeah. But the answer is yes. Yes. Obviously, somebody's got to take care of the kids. And again, remember here, she doesn't get rehabilitative unless she actually goes back to school, whatever the school is. It is her choice. But now the statute requires that plan. So she's got to show that she's going to spend 3 years, or I guess she never started law school. So yeah, 3 years in law school or 4 years in medical school or whatever it is that she's going to do. Okay, durational. And I heard a lot of, yeah, we'll give her durational. You give durational if you don't give permanent, right? And 15 years. What's the cutoff for 17? Yeah. Now, permanent is something that could be given in this situation if you have extraordinary circumstances. I kind of doubt that this is a case where a court would give permanent. More likely, I have to agree with those who are saying durational. And it's for a set period, whatever it is that the court, and you don't have to pick the period. Unless you want to, you know. You just got to say it's for a set period, right? And again, some of this stuff is in there again. That's just there to review. Permanent, again, it's a 17-year marriage, but remember, if you're in that intermediate area, the statutory factors that we're going to look at, if they stack up in favor of permanent, it could be awarded. And she is close, 15 years, 17 years. Yeah, but I would go with durational here, personally. Okay, now let's, we don't need that. We already talked about it, short-term, moderate, and long-term. Statutory factors, though. Once again, somebody out there might know all of them. If you do, by all means, spill them all out. If you don't know them, at least look for what matches up with the facts. So we look at, let's get to the factors. Okay, standard of living. And of course, they set a fairly high standard of living as it's described, because he was a doctor and the this and the that. So that's a factor that can be taken into account in the amount of alimony that's awarded to her. Duration of the marriage. Well, we already discussed that and its importance. Age and physical and emotional condition of each party. That's why they told you that they're 37 and in good health. So use those facts. Again, you see a fact, say, okay, that can be a factor for X. You know, let it refresh your memory, if you will. Financial resources of each party. Husband's got all sorts of money, and wife at this point, she's a homemaker. She worked in a department store for a while. She does it. I think she actually had a college degree, but think about it for a second. Yeah, she got into law school, so she must have had a college degree. But what does a college degree get you these days? A job at McDonald's, right? Yeah, job at a department store. So, earning capacities, same thing again. Husband's got all the capacity, and right now she doesn't unless she gets law school or whatever school she goes to.
Can you get durational with a rehabilitation plan?
Yes, you can. Yes, absolutely, you can. Yes, what you can't get is durational and permanent. That doesn't combine. But durational and rehabilitative, absolutely, absolutely. Contribution of each spouse to the marriage. Remember, he contributes the money, but he's never around. She contributes everything else. And she did contribute money when she was working in the department store. Yes, ma'am.
Can you get, it's bridge the gap, rehabilitative, and moderate can all be awarded, right?
Yes. Yeah. Yes, absolutely.
So
What?
things that can are permanent and
Durational, correct. Tax treatment, I've never seen them test that one. I wouldn't worry too much about it. But obviously, if it screws up somebody's tax bracket, that can be taken into account. And sources.
And also, isn't alimony revenue?
Yeah.
And
Oh,
it's
yeah.
expense for the doctor.
Yes. Yeah. So you just take those things into account, and it actually paying some alimony might help him with his taxes. You know, I don't know. Yeah. And of course. Our catch-all. Oh, I'm sorry, skipped over the affair. Sorry. Chris wants to talk about the kids. I forgot, as I was looking at the page, here's where we do have an express statutory factor dealing with the affair. Once again, though, the case law is saying it is a question of depletion of assets. And then our catch-all. Anything else? Yes, sir.
Don't you also take into account like the alimony? I mean, if it was her cheating on him, you'd take into account.
Yeah, if she's selling off his watch collection.
Right. If she's depleting assets.
Can't you, if she's sleeping with someone, can't you see it as her being in another relationship, so kind of deducting from the alimony?
No.
Not really.
It's not substantive like that. It's
Yeah.
economic.
Yeah. Well, that's different, yeah. And if he's supporting her, that's different too, but just the affair, no. Okay, okay, so what am I going to do? I kind of, somebody already suggested, I think, I'm going to give her a little bit of bridge the gap, rehabilitative, and durational. But I don't, permanent, I kind of doubt it, yeah. Yeah, exactly. So it was a nice little conclusion. Yeah, you're racking up points with something like that for sure. Okay, so we don't need that. Okay, parenting responsibility. I'm using the PC term now instead of child custody. And remember, in Florida now, shared parental responsibility. In addition to, of course, Chris, the best interest of the child. But don't talk about custody one way or the other. That's not how it works in Florida. And
Because the call to question says custody.
I know, because it's an old question.
It's old, I got you.
I didn't change that. I left the text as it was. Shared parental responsibility, that parenting plan, and of course, statutory factors. They love those statutory factors. So, okay, now, if you really, really, really want to sound like you know what you're talking about, then it is best interest of the child and In conformity with the UCCJEA. That's what the statute says. So, like I say, extra points. It's best interest of the child and in conformity with UCCJEA. This question doesn't have any provisions dealing with the UCCJEA. Go back and review it. They love to test it. Yeah. They love to test that. So just, and you know.
That's a multiple choice. I see that a lot.
Okay. Yep. So just, you know, be aware. Okay. That's just stuff. Parental responsibility is to be shared. That's our presumption, if you will, unless it's detrimental to the child. And honestly, the only time I've seen them put a fact pattern together where it might have been detrimental to the child, I think it was the wife who took the kid to live with a cult that dealt with and handled poisonous snakes. Okay. Yeah, it was part of their religion. Yeah, yeah, right. But it's an old question. She took the kid, went to live with the snakes, and maybe then it might be detrimental to the child. But honestly, it's unlikely that they're going to give you a question today where.
Abuse, any of that stuff.
I'm sorry?
Like any abuse and stuff.
Yeah, right.
Well,
Yeah. Oh, well, that's a factor. Abuse is certainly a factor to be considered, of course. And it could come up. I haven't seen it come up, but it could. What I doubt, though, is that they're going to give you a fact pattern that's so one-sided that the kid's going to end up living solely with one parent. That's just not what they're going to test. And you look at the expressed desire of the parents, and, of course, we look at, as we're going to see, the preferences of the kids in a moment.
You know where that also pops up? I remember is it goes to that if they're gonna going back to like a war-torn country and it's in active war.
Okay.
Then
Yep.
they won't do it, but say the parent's a military guy and he wants to go to a military base, that's not enough.
Okay, that's okay. Yep, that makes sense. Parenting plan. You have to have a parenting plan, and perhaps some of you have had experience with it. That parenting plan has to be detailed. Every hour of the day is planned out for the kids, and the court is very serious about the parenting plan. So don't forget to mention the parenting plan. The parents make the parenting plan, and then the court approves the parenting plan. Big part of the process. You can't write a good question unless you at least mention it. So our parents have got to sit down here and come up with the plan, and of course it's got to map out everything, and as some people have been saying, you can divide up the parenting responsibility. In fact, that's what's likely to happen. Mom takes Susie to her karate lessons, and dad takes Bobby to his soccer play or whatever, or mom is the one who goes to all the sporting events and dad takes the kids to the doctor or whatever. However it works out. It's that detailed. It's got to be specific, and it's got to cover all the different responsibilities. They can divide them up any way they like as long as it makes sense. And UCCJEA again, because of course, remember, going back to Chris says, well, we're going to take the kid out of the country. You got to take UCCJEA into account anytime a kid goes out of a jurisdiction, right? Okay, you get to say best interest of the child again, Chris.
Best interest.
But don't write it every sentence, okay? Because that gets old really fast. Only where appropriate, okay? Okay, so statutory factors. You're going to get tired of the statutory factors. They are kind of. So use the facts and kind of do the best you can with it. But make sure, even if you're not real familiar with the area, when you write about equitable distribution, say something about statutory factors. When you write about alimony, say something about statutory factors. When you write about parental responsibility, say something about statutory factors, because you will get a lot more points if you can recognize that those factors are there in 3 places. So we're going to look at whether each parent can facilitate and encourage continuing parent-child relationship, honor the time-sharing schedule, and be reasonable when changes are required. I don't see anything in this fact pattern that suggests that either parent is going to be problematic with that. But you can say whatever you
know
like.
what they would say about this? Is you would say the doctor, because he has a specialty as a doctor, would get the responsibility for the medical decisions.
Sure.
And the lady,
Sure.
perhaps, you know,
Takes the job.
does the school and.
Sure, absolutely could be. Or he could say, you know, I see enough of doctors every day, you take them to, you know, to the pediatrician. Whatever they want, and whatever you want, honestly, you wouldn't have to go into a whole lot of detail, because you don't have to make the plan for them. I've never seen them do that. That would be not fun. Yeah, they just make one. What else do we look at? Anticipated division, which we're just talking about. How are we going to divide? And here, perhaps it's a little on the sexist side, but I think the wife would probably continue to be the daily caregiver for the kids because they're young and that's what they're used to. And so it's not so much being sexist as what are they used to, which is important. If the husband had been the one staying at home and caring for the children, I would say he would continue to do so. Notice they've always been in the same home, attended the same school. Use those facts. We're going to keep them in the home because they've always lived there. They've always gone to the same school. We don't want to move them to other schools.
Do you know what that is?
I'm sorry?
That's the best interest of the child.
Yes. Yes, it is, Chris. There's a game that we used to play in law school, I'm sure everybody plays. It has variations on the theme, and sometimes it's how many times somebody speaks. Okay, I won't call it what we used to call it, but you probably call it the same thing. And okay, but the other game is how many times some certain something was said.
I get both.
You get okay. Geographic viability. You know, this here, that one's probably not an issue. But again, if you've got a parent who's going to move to another state, you take that into account. What else do we want to look at? Moral fitness of the parents. Once again, in this case, the fact that the husband has had an affair is not going to be significant. If the kids walked, and there is, excuse me, there is actually one question where that I recall where the kids walked in on probably the father in the middle of having the affair. Maybe if it shocks the kids, I don't know. But usually the affair is not going to affect parental responsibility. Mental and physical health of parents, again, they tell you that they're both fit. And homeschool community record of the child, we don't have that in this case, but so, of course you would take it into account. Now, preference of the child, statute specifically says you take it into account. Again, I'm pretty sure that they gave you an 11-year-old girl and an 8-year-old boy for a reason here. You can conclude whatever you want, honestly, but I'm guessing the 11-year-old girl has the maturity to say what her preference is, and the 8-year-old boy might not. But if you think otherwise, it doesn't matter as long as you use the facts. Other things like, what do the parents know about the daily activities? The wife is the one who knows what the kids are doing right now. It's not to say the husband couldn't learn. So I wouldn't use that against him. But going back to a point somebody made, maybe since she already knows the school schedule, she's the one who deals with getting them to school and to and from school. Maybe she is the one who knows, you know, their various sporting and other outside activity schedule. Other things like, can they provide a good home and routine? Surely the wife can. I think the husband probably can here too. If he's the, you know, what is he going to do when he has the kids at his house? You know, they're going to go back and forth. And he's going to have somebody there, right? He's going to hire a caregiver. So I think he can provide that atmosphere. And they both can stay informed. There's nothing in the facts that suggests they're going to have trouble communicating with each other. So I don't think there's anything here. There's your domestic violence somebody measured before. If you had it, of course, that would affect the responsibility, but you don't. Customary tasks, again, if it's easy for them, it's what they've been doing, they can continue to do it unless, of course, a spouse objects and says, no, I want to step in and do whatever it is. Most of these, they're starting to repeat a lot, because in this particular place, these are newer statutory factors. There are a lot of them, and they do kind of all blend together. So just use those facts and use them in a way that kind of suggests statutory factors if you don't know them all. So what's my conclusion? I'm definitely doing joint parental responsibility here. They make the parenting plan, and I would, however, because of the circumstances, make her primary caretaker, which means she lives in the house with the kid, and they split up the responsibilities otherwise. Okay, final, child support. Good news is on child support, it's going to be a relatively short section of your answer, because you can't take a calculator into the exam. So we're going to talk about duty to support and statutory guidelines, and that's, again, it's relatively short. So both parents, of course, have that duty to support. And there is a worksheet. So again, you want to sound like you know what you're talking about. They have to fill out that child support worksheet. And they show what their income is, because we're going to be talking about combined income, and we impute income if somebody's not working, of course. Besides the fact that if somebody's voluntarily not working, if somebody fails to provide the information, you impute income, obviously. Statutory guidelines. If there's anybody in here who's actually been clerking in the area, or you had family law, you might know what those. It goes on, page after page after. It's long. There's no way that you need to clutter your brain with that information. So what do you need to know? Top tier, middle tier, where you're using the guidelines, and low tier. So if we are less than 800, the low tier, then we're going to go on a case-by-case basis. The middle tier, it's from 800,000 to 10,000 a month, which comes out to 120,000 annually, which is most cases. That's where you'd use the statutory table. And then above the 120,000, then you use percentages depending upon how many kids you have. If you can say that much, you're golden, because they can't go into much more detail than that. Now, make sure you know about the discretionary variance. And honestly, this is something that most people remember, right? The plus or minus 5% rule. And yeah. So the court is going to follow those guidelines, and then can vary plus or minus 5% for things like braces, other glasses, things like that. You can take into account independent income of the child. Suppose that you've got a child model or actor or something like that, kid who's earning money, the court can vary on the downside. And what else? Seasonal variations in income. Maybe you've got somebody who is stone crab commercial fisher person. Okay, that's seasonal. Age of the child. And for the most part, your normal little kids, you get diapers and stuff like that, but it's when they get into high school, right? And they got all these activities, and they got the braces and the this and the that. The older the child gets, usually the more likely it is that the child's going to be more expensive. Special needs, of course. And occasionally I've seen them test special needs. If you've got a special needs child, you got to take that into account. And don't worry about this part. This is just, again, extra stuff for you. Now, there is a mandatory variance if you, and I don't know, I haven't seen it tested. It's a relatively new provision, but the court has to vary from the guidelines if the child is spending a substantial time with the obligor parent. So in other words, if the kid's with you a lot, then you pay less, right? And so they both have to pay. That's about all you can say here, till the kids reach the age of majority or are emancipated.
You don't get into modification or any of that stuff?
If they ask you about it. Yeah.
Or if you have time.
If you have time, yeah.
Circumstances substantially change.
Yes, exactly right. Okay, that's it unless there are any questions. Next week, remember again, a shorter session, which will be good for you, on business entities, and then the following Wednesday after that will be the review session. Please, several of you have said, oh, can I send you essays? Yeah, by all means. Just email them to me and either send me the question or tell me the month and year of the question so I know what you're writing about. All right, that's it.